Good morning all. I'd like to warmly welcome you to this online conference hosted by EMN Ireland, supporting integration, access to citizenship in Ireland and the EU. I particularly welcome our speakers, both international and from Ireland, Maarten Vink, Roisin Dunbar, Catherine Cosgrave, Tuka Lampe, Isil Tonahan, Michal Polachowski, and Ricky van Urs. My name is Fran McGinnity, and in my job as researcher at the ESRI, I am coordinator of a research programme on integration and equality, and I'm also senior research advisor to EMN Ireland, so have a special interest in this event, in particular the role of host country citizenship acquisition in supporting migrant integration. This conference is organised by the Irish team of the European Migration Network, a Europe-wide network. The aim of this network, the EMN, is to provide up-to-date, objective, reliable and comparable information on migration and asylum at both national and EU levels, with a view to supporting policy making and informing the general public. Having EMN housed at the ESRI is hugely beneficial for a range of research on migrant integration, so we can benefit from the team's expertise, from their outputs and their networks, both in Ireland and in other European countries. And today's conference and publication is another example of this. I'm going to be chairing the keynote and the first session of the conference. Alan Barrett, our ESRI director, had wanted to chair the morning, but has had a recent family bereavement, so I am taking his place. As many of you know, Ireland has seen profound changes in terms of national and ethnic diversity in the past 25 years, accompanied by significant changes to citizenship in the past 15. Citizenship may be viewed as the highest level of membership available to migrants in their host country. This conference presents an opportunity to reflect on what Irish citizenship means today, what benefits it might or might not confer, who is acquiring Irish citizenship and under what conditions. Acquisition of citizenship is sometimes seen as a result of integration, but it can also further improve economic, social and political integration for migrants, or at least their prospects. Having international colleagues coming to share the experience in other countries allows for a more thorough and informed analysis of this important social change in Ireland in light of international experience. Having a number of speakers focus on different aspects of the Irish experience allows us to set the Irish experience in context. Turning briefly now to practicalities, I guess it goes without saying I won't have to tell you where the toilets are or how to leave in an emergency. I presume you know that yourself. But in terms of Zoom, this is a webinar, so the only people who can speak are speakers and session chairs, known as panelists. Any questions on the presentation should be typed in the Q&A box, and the chair will read them out at the Q&A. There's various sessions, so feel free to send in your questions during the presentation. You don't have to wait until the Q&A session. I'm afraid you're going to have to supply your own coffee and tea, and we won't be able to speak informally as we would in events like this, but these are the strange times we're living in. Now it gives me great pleasure to welcome our keynote speaker, Professor Maarten Vink. Professor Vink is Chair in Citizenship Studies and Director of the Global Citizenship Research Area within the Global Governance Programme at the Robert Schuman Centre for Advanced Studies at the EUI in Florence. He is also co-director of the Global Citizenship Observatory, GLOBALCIT, so is excellently placed to speak to us today. Maarten will provide a keynote talk presenting his international research on the impact of host country citizenship on the labour market outcomes of migrants. We really appreciate Maarten taking time to speak to us today. He'll speak for about 30 minutes. Over to you, Maarten.
Excellent. Many thanks, Fran. Can you hear me well? Okay, excellent. Good morning, everyone. Thank you, Fran and Emma, for the very kind invitation to speak here this morning. I'm delighted to have the opportunity. I'm sorry, of course, that we cannot meet in person, but in this way, I suppose more people can join who otherwise wouldn't be able to participate in this session. The program looks extremely interesting. I look forward to all the other presentations, and congratulations also to EMN Ireland on the publication of the very interesting report on pathways to citizenship in Ireland, which came out yesterday, and I had a brief look at that. My talk today will be about the relationship between citizenship acquisition by immigrants and their labor market outcomes on the other hand. Now, of course, citizenship acquisition in itself is a value in its own right. As Fran already alluded to, it's the highest form of political membership. It is in many ways a form of political equality, at least formally speaking. And of course, it comes with the most secure resident status. It provides migrants with global mobility, especially migrants who come from countries where their passport gives them less global mobility in terms of visa-free traveling around the world. Within the European Union, of course, the acquisition of citizenship grants not only national citizenship, but also EU citizenship. And of course, within states, acquiring citizenship provides an immigrant with the opportunity to vote and to be elected. So the franchise, of course, is the reflection of the political equality. So those reasons in themselves are already sufficient reason, I think, to be interested from a societal, political, and academic perspective in citizenship. But as Fran indicated, citizenship acquisition has also been tied in with a broader research agenda on immigrant integration. So that is a research agenda and a political agenda about migrants finding their way into society, long-term settlement, and becoming part of the destination country society. And as part of that integration agenda, the labor market outcomes represent a form of structural integration, as we refer to this in the literature. And you can think here particularly about employment and also about earnings. So that's what I will be talking about today as the research field on the so-called citizenship premium that is maybe most vibrant in academia. So there's the most extensive research agenda on the citizenship premium in the labor market. There are other, of course, forms of citizenship premium, political socialization, feelings of belonging, staying in a country or leaving a country. So there are all kinds of other things that we might talk about in terms of outcomes associated with citizenship acquisition. I will talk today particularly about labor market outcomes. Okay, and I want to talk about well, three main things. First, I would like to contextualize this discussion in the broader political debate about the conditions under which migrants can have access to citizenship. There will be much more reference, I think, to this debate in the subsequent presentations, but it's important to contextualize this also for my discussion. And this is the so-called catalyst versus crown discussion. That's mostly I would say, a political framing, but we've seen that also in academia, this political framing has inspired research on the relationship between citizenship and labor market outcomes. So very briefly, is citizenship a catalyst for integration? Can it spur on integration, or should it be seen as a crown of integration, only come at the end of an already completed integration process? And those framings are associated with different ideological positions on making access to citizenship more or less restrictive or facilitated. Now then, I would like to share some approaches from the literature, and there are two things that we should discuss. Theoretically, why would we actually expect a relationship between citizenship acquisition on the one hand and labor market outcomes on the other? And secondly, if we can think about mechanisms that might connect citizenship and labor market, how do we actually investigate this? And I'll talk a bit about the chicken and egg problems. So this is a question about causality. Can we actually say something about the causal effect of citizenship on labor market outcomes? And I'll show you two different ways in which we have dealt with this in the literature. Then I'll share you some findings, conclude briefly, and Fran will stop me if I talk too long. Okay, let's talk about catalyst versus crown first. So this is a debate about the conditions under which citizenship can be available, and what we know from the literature. And if you are not so well versed in this, I advise you not only to look at the EMN study from Ireland that came out yesterday, but also the broader EMN study on pathways to citizenship in the EU. And we see, and we also investigate this in the Global Citizenship Observatory, which I co-direct, as Fran indicated. We know that the conditions for citizenship vary widely. Here you see a table from the EMN report on residence conditions. So this might vary in Europe between more or less 5 to 10 years for ordinary naturalization, but in many countries there are also more facilitated provisions for specific groups. The European Convention on Nationality capped the residence requirement at 10 years. But in previous times this was also longer in some countries, and we see in other countries around the world and Europe that the residency requirement might exceed even 10 years. Now, so the conditions vary greatly, residence, but of course also language requirements, civic integration requirements, the fees that one has to pay, criminal record requirements. Many of those things I think will be addressed in the subsequent presentations. What interests me is how these conditions translate into, first of all, naturalization outcomes. And actually that's the part where we can be, which is, you could say, a bit easier to investigate academically. There's a quite well-established literature on the relation between the conditions for citizenship and citizenship acquisition rates. And we see that the conditions translate quite neatly in naturalization rates. Generally speaking, if the conditions are more facilitated, we see higher naturalization rates. I put here naturalization rates between brackets because the Eurostat data from which this picture from the EMN Ireland report comes also come with a couple of caveats. In recent research that I've been doing with colleagues, based on administrative data where we track about 650,000 migrants over time, we look at so-called cumulative naturalization rates, and you see these differences in the conditions even translating in larger different naturalization rates. So in Sweden, we see that after about 20 years, almost 80% of the migrant population has acquired Swedish citizenship, whereas in Denmark, this is only about a third, and in the Netherlands, this is only about 2/3. And this corresponds quite neatly with the most liberal policy in Sweden, the most restrictive policy in Denmark, and the sort of intermediate policy in the Netherlands. And in the paper that I refer to here at the bottom, which you can find the preprint online, we also look at changes within countries and how that translates then to delayed naturalization rates. Now these conditions reflect different political positions. In my own country, the Netherlands, we see that mostly countries on the left, so here are citations from the green left, they argue that naturalization is a catalyst for integration, whereas parties on the center right, they see citizenship as a crown on participation and integration. And it's something that you really have to work very hard for, as the parliamentary leader of the Liberal Party argues here, Dijkhoff. And these connect to the two classical paradigms: citizenship as a catalyst for immigrant integration. It should be accessible because it fuels subsequent integration, or it should be a crown for successful integration. We shouldn't make it too easy. It should only be available under strict conditions, because otherwise it cannot incentivize migrants to invest in their own country, in their own integration process. Okay, so that's the first step of the broader, you could say, political and academic debate in which this talk can be placed. Now let's move on to labor market integration. I already mentioned that immigrant integration is a multidimensional concept. I don't propose that we have a discussion here on what immigrant integration is, at least not maybe as part of my talk, as part of the overall session. Of course, that would be an interesting and welcome discussion. I focus here specifically on labor market outcomes. And in the literature, we have looked mostly at two types of outcomes. Actually, we've looked mostly at earnings, income associated with employment. But we have also looked at employment as such. So are naturalized migrants more likely to be employed? And is that also reflected in higher earnings? Now, let's think a bit about how the two are theoretically connected, citizenship and employment and earnings. And here we can use this framing of catalyst and the crown perspective. I would argue that the catalyst perspective is much better theorized. Actually, most of the scholarly contributions place themselves in this catalyst perspective, and there is actually not much theorizing nor empirical evidence, I would argue, for the so-called crown perspective. That doesn't mean that that is maybe, it doesn't necessarily need to mean that that's not a legitimate political position, and that's why maybe the crown and the catalyst perspective are not necessarily mutually exclusive. But it's important to say something about, from both perspectives, how we would see this relationship. And from the catalyst perspective, you might argue that there are three reasons for why citizenship would translate into better labor market outcomes. The first one, maybe the most obvious, I think it's generally seen as perhaps the least relevant, empirically speaking, is that as a citizen, you might have access to a selected number of public sector jobs. You could think about working in the police, working as a police officer, or in the Netherlands, for example, it's being a judge. And of course, you cannot be elected into parliament if you are not a citizen. Now, this is, I think, true. It's generally acknowledged. Also, these type of, we actually don't have a very good understanding of how the access to how public sector jobs reserved for citizens vary across countries. So that may also be something interesting to discuss. I'm not aware of a really neat comparative overview. Generally speaking, this is thought to be empirically not the most important reason, because of course there are only so many public sector jobs available that are restricted to citizens. So when we look at the literature, we see reasons 2 and 3 being more prevalent. And the second reason is actually the reason that is most often discussed in the literature. And this is the so-called citizenship as signaling device argument. And for this, you have to keep in mind that when we talk about labor market participation of immigrants, immigrants actually face strong challenges. Fran, I'm sure, can tell you much more about this. Migrants face all kinds of challenges because, and when I talk about migrants, I talk about foreign-born persons, right? So people who are born in a country, move to another destination country. And this brings with it many challenges, in the sense that You might have, if you migrate at a later age, you might have already some education and training and maybe even work experience, but that might not translate in a neat way into the labor market of the destination country, the country where you reside. So there's that problem. There's also the problem of discrimination. This can be what we call taste-based discrimination, for example, racial discrimination. Here, citizenship, of course, cannot overcome taste-based discrimination. So here it's important to keep in mind that citizenship may be a catalyst, but it's not a miracle device that solves all problems of immigrants. But immigrants also face so-called statistical discrimination, and that's the form of discrimination where employers have to make choices about suitable candidates. They get maybe many applicants, and they have to take certain shortcuts to making decisions. And with somebody who is born outside of the country, they may just be less certain about the background of that person. Is he or she going to stay in the destination country? Does it make sense for me as an employer to invest in this future employee? And so there's all kinds of, there's greater uncertainty with hiring immigrants. And here it is generally thought in the literature that citizenship may overcome some of that statistical discrimination. So employers may be more willing to take a chance if a migrant has resided in the country for a certain period, has committed to living in that country, and has acquired citizenship of that country. And therefore, also in some countries that may also require a certain investment into skills. And thirdly, citizenship may also be a catalyst from the perspective of incentivizing investment in migrants' human capital. If you're not sure that you can actually stay in the country, build up a life in the country, are you really going to invest in acquiring the skills in terms of education, on the job training? And citizenship might provide certainty for an immigrant and therefore also spur this investment in human capital. From a Crown perspective, we are generally much more skeptical about this relationship. People from this perspective would argue that citizenship has limited added value. It has only symbolical value. Symbolical value may, of course, be still very important from a subjective perspective or from a political perspective, but maybe from a labor market perspective, we wouldn't expect a great added value to the rights that one already has as a permanent resident. And the most important argument that is most often heard from the Crown perspective is that making citizenship available under two moderate conditions will knock out the incentive for an immigrant to further one's integration. So it should be a Crown. We first want to have an immigrant demonstrate that he or she can build up a life, and only at the end of the integration trajectory should citizenship be rewarded. Okay, I have to keep an eye on the time. So let's talk a bit about the chicken and egg problem. So if we want to investigate whether citizenship has a causal impact on labor market outcomes, we run into the problem that it's not so easy to investigate. And I'm talking mostly about quantitative research, whether it is really the citizenship that makes an immigrant do better in the labor market, a naturalized immigrant do better in the labor market, or whether there are some aspects of immigrants that make them more likely to naturalize that also translate into these better labor market outcomes. This can be visualized in an abstract way like this. So we are interested in the blue arrows. A migrant acquires citizenship and that translates into integration outcomes. But the red lines complicate this. There may be some characteristics of migrants that we cannot measure very easily. For example, migrants may have a stronger determination in life. They may have more perseverance, and that may reflect in better labor market outcomes. And once they do better in the labor market, they might also be more inclined and more able to acquire citizenship. So it may be that citizenship actually reflects the better integration rather than spurs on the integration. So that's the general problem that we have to deal with in the literature. And there are two ways to we have dealt with this. And let me introduce them very briefly, just to give you a sense of how we deal with this. And these are what I would call the longitudinal approach and the quasi-experimental approach. Now, the longitudinal approach uses data, but of course, as you know, we can do a survey and ask migrants, are you naturalized? Do you have a job? What are your earnings? And then make a correlation between these two. If we do that, that would be a very naive way to do this, because there are these underlying elements that might reflect both in the citizenship acquisition and in the labor market outcomes. And so this would be the cross-sectional survey where we ask immigrants only at one point in time about their citizenship and about their labor market situation. But if we use panel data, so we have repeated observations of an immigrant's citizenship status and of her or his labor market situation, we are able to track the performance both of citizenship and of the labor market, and we can compare the outcomes on the labor market before and after the citizenship acquisition. And in this way, we can control for these characteristics that are generally difficult to observe, like perseverance and determination in life, that are not easily asked in a survey, but we can control for these time constant unobserved individual characteristics by only looking within individuals before and after citizenship acquisition. That's the most generalized approach in the literature. There's also a second very interesting approach, which is more difficult to generalize because the conditions under which we can apply these kind of approaches are rather idiosyncratic. But I would like to mention this since there is quite a bit of literature on this, and especially from the case of Switzerland, where researchers have done a so-called experimental approach. Now, nowadays with COVID vaccines, we know all about randomized trials. We are all experts on epidemiology and also on trials. And of course, in a randomized trial, we would give the vaccine to one group and a placebo to another group in order to see whether the vaccine really helps prevent the onset of COVID. That, of course, we cannot do in this literature. We cannot experiment with immigrants and make some citizen and others not citizens. So we cannot randomly attribute citizenship that would be unethical. But we can make use of some existing experimentation, randomization, which is what we call a natural experiment in the literature. And the Swiss case is an interesting example. It's interesting from an academic perspective, problematic from a societal perspective, because until 2003, citizenship, like many things in Switzerland, was decided by referendum. So immigrants had to submit their application with a short resume, and there would be votes about this. If you would receive 51% yes votes, you would be a citizen. If you would receive 49% yes votes, you would not be a citizen. This has later been ruled unconstitutional by Swiss courts because it obviously led to discrimination, because certain types of migrants would be more likely to be citizen than others. But researchers have used this to randomize the attribution of citizenship, because you could argue that between those who get only 49% yes votes and 51% yes votes, they're actually we can assume that they are very similar on many characteristics that we are interested in. Okay, maybe a couple of minutes, friend. To
yeah, maybe we could take another 5 minutes. Okay. Maarten, yeah.
So to share some of the findings, right? So we know something about the contextualization, the theory, the method. So what do we find in the literature? Well, could say the general conclusion is that we find much more evidence in favor of the so-called catalyst approach. There's actually much less evidence on the crown perspective. It's a very short summary, but let's look at what we find in the literature based on these two approaches. And that actually, what's interesting is that they very different methodological approaches, but the findings are more or less the same. So when we look at the literature from the longitudinal approach, this has been applied, for example, in Germany. There's an interesting comparison between Denmark and Sweden, two countries with very different citizenship regimes, but the citizenship premium was quite comparable. And I've done with colleagues in Maastricht, especially with Floris Peters, research on the citizenship premium in the labor market in the Netherlands. What we find generally is that there is a clear evidence for a citizenship premium in the labor market, which translates into higher earnings, and that this is stronger, or in quite a few papers we find that this is exclusive, so only for non-EU immigrants, or generally for more marginalized groups of immigrants. And that has to do with the idea that as an EU immigrant, of course, you face much less constraints in the labor market in terms of your status. You have already a quasi-citizenship status. You might face less discrimination. I recognize that here, of course, within the group of EU immigrants, there is also a lot of variation. So that will be interesting to maybe discuss also in the Q&A. Generally, we find that there is a citizenship premium, but it is much stronger among migrants who stand to benefit most from citizenship. So migrants who face stronger constraints in the labor market, migrants from less developed countries, and this adds to an increase of 3, 4, 5% in labor market income. What's interesting is that we find, if we think about the theoretical reasons, we find evidence both for the signaling argument. So we see a boost in earnings after naturalization, but we also see evidence of already what we call in our work an anticipation effect. So migrants who have a reasonable expectation that they can become a citizen, and that's certainly the case in the Netherlands. If you are able to fulfill the conditions, there is no discretionary decision anymore. So you can already orient yourself to the moment where you might be a citizen, and the conditions are relatively feasible at the moment, at least with the language requirement of A2. We see that already earnings develop positively prior to naturalization. Now, what's very important is that this citizenship premium is not unconditional. So it matters also under which conditions do you acquire this, and what we that's I think interesting to keep in mind in the discussion in the subsequent panels, that we find in our paper, but we see this also in the evidence from the Swiss case, that in as far as there is a citizenship premium, this is especially the case if the citizenship acquisition takes place earlier in the settlement trajectory. I think this is a very plausible finding from the perspective that, from the anticipation perspective, right? If you think about signaling, we wouldn't expect that it makes a big difference, because if employers use citizenship as a shortcut to overcome statistical discrimination, and it shouldn't matter whether an immigrant has recently becomes a citizen faster or later in the settlement trajectory. But from the anticipation, human capital development perspective, I think it makes a lot of difference. If you want to encourage migrants to become part of society, to acquire the skills that are required to find their place in the host society, can we realistically expect that this will still take place if an immigrant becomes a citizen after 10 years or even later in the settlement trajectory? I'm not so sure. And so the catalyst perspective we find is especially relevant earlier in the settlement trajectory. So the last finding here, just to show you from the Swiss case, and you can see this later maybe at your own pace when the conference will be made available online, or look in the open access publication. We see that winning Swiss citizenship in this referendum, even for migrants where the difference between the yes votes and the percentage of yes votes was relatively marginal, we see that this translates into long-term substantial differences in income trajectories. So the green lines here refer to the migrants who were just granted Swiss citizenship, the purple lines to those who were barely rejected. And we see that if you look at panel C in the bottom left corner, you see that until the moment of naturalization, the income trajectory is quite comparable. But once the purple group of migrants who are rejected for Swiss citizenship, their income increase stabilizes and even declines over time, whereas the migrant group who wins citizenship actually sees a positive income trajectory, and this translates to about $5,000 annually over the subsequent 15 years. Okay, concluding.
Okay.
So we see that this is a complex relation, but actually there are interesting ways to deal with this chicken and egg problem. So there are various strategies, and irrespective of which strategy we take, we find more or less similar results. It's a politically controversial debate. We find overall that citizenship functions more support for the catalyst perspective. And what really matters that it's not only whether citizenship matters, but especially under which conditions does it matter, to whom does it matter, and how does citizenship matter for the labor market. Thank you.
Thank you very much. Thank you so much, Maarten, for that very rich and detailed presentation, giving a superb overview of a large and complex literature. I mean, it is interesting to have the evidence from the Swiss experiment, though I'm glad we're not in the Swiss situation of having referenda on citizens here in Ireland, but and it's certainly also the case that citizenship acquisition among non-EU nationals in Ireland has been much more dramatic and rapid in recent years, though this is changing. So now I think perhaps given the time, I have a number of questions myself, but perhaps given the time, we should move on now to the first session, if that's okay with you, Maarten, and then we'll have the people can pose questions on Maarten's presentation then in the Q&A after the first session. Just in order to keep time. That's the issue with Zoom, is that we're trying to keep things moving on. So the first session, as Maarten clearly outlined, citizenship is usually attained by migrants through the naturalisation pathway rather than by birth or descent. And in this session, we'll discuss the process of applying for naturalisation, both in Ireland and then in the third presentation in Finland. I'd first like to welcome Roisin Dunbar. Roisin worked with the Irish National Contact Point of the European Migration Network, and she co-authored the EMN report, Pathways to Citizenship Through Naturalisation in Ireland, which, as Maarten mentioned, was published yesterday. Roisin has recently graduated from NUI Galway with an LLM in International Migration and Refugee Law and Policy, and she's currently a researcher with the UN Special Rapporteur on Trafficking in Persons. Roisin will now present the report on pathways to citizenship through naturalisation, placing Ireland in an EU context. Over to you, Roisin.
Great, thanks, Fran. It's great to see you again, and thanks for inviting me back to present this research. So, like you said, this research was launched yesterday, so it presents data and also places Ireland within an EU context in terms of policy. So it documents Ireland's naturalisation policy and process. So we'll just look over in the next slide of the overview of what the presentation will be. So first of all, naturalisation is not the only manner in which to gain citizenship in Ireland. So we'll look at briefly of the other modes of acquisition of citizenship in Ireland. Then we'll look at the recent data on this, the naturalisation conditions, mainly focusing on residence requirement and the good character requirement, but also comparing with other EU member states. Then finally look at the processing of applications in Ireland and in the EU, and just to finish up with some conclusions. So just next to look at the modes of acquisition of citizenship in Ireland. So from birth, this is still a possibility. Prior to 2005, for children born before 2005, this is the use solely citizenship, so based on a birthright citizenship. After the 2004 referendum, this changed to citizenship kind of conditional on your parents' citizenship or residency. Citizenship can also be obtained by descent, so this is used the Foreign Birth Registry with the Department of Foreign Affairs. Also, citizenship is automatically applied at birth to prevent statelessness. This is in line with Ireland's statelessness obligations. A government decision can be taken to grant citizenship to a person as a token of honour, and then finally naturalisation, which will be the focus of our report, which is the focus of our report and presentation. So next, just to look at the data on citizenship, and just to, I suppose, give a bit of a health warning nearly of that data cleansing is beginning to take place on some of these figures, so that in the report they may slightly change a little bit, but that's just becoming more accurate, I suppose. And important to note that more recently data has been disaggregated based on nationality in 2015, by age in 2017, and by sex in 2018. So this is in line with the migrant integration strategy. And also under Ireland's obligations with EU migration statistics regulations, data can be found on Eurostat, which is where most of the data from our publication has come from as well. So next we'll just look at the actual figures. So we can see here a kind of curve almost, and what is interesting to note is the kind of peak points in total applications received, valid applications received, and certificates issued, especially the disparities between that. So if we look kind of steady growth in early 2000s, which we discussed in the report, isn't on this graph here. So between 2000 and 2005, 7,200 people received citizenship through naturalisation. The unprecedented numbers of application, in line with, I suppose, the increase in immigration in Ireland in the early 2000s and late 1990s, led to backlogs in the departments because of these unprecedented numbers. So you can particularly see that in the difference between total applications received and valid applications received. So in 2011, measures were taken by the department to resolve this issue. So that included an increase in staff, new application forms which were more simplified and easier to fill out, and also streamline and accelerating kind of checking procedures within the department. Interesting, at this time the department also funded a project with the New Communities Partnership, which would assist persons applying for citizenship. This project still runs, it's just no longer funded by the Department of Justice as of 2017. So yeah, we'll look at the next slide, which will look at our non-EU counterparts, and you actually see a decrease in numbers here. I suppose the situation, I think, is just given a decrease in immigration to Ireland as well has kind of led to this. And so we look at the next slide, kind of compares the two here with non-EU nationals and EU nationals. So we see a slight increase with EU nationals, which is interesting. Part of this may be explained by uncertainties surrounding Brexit and former expats of Ireland in the UK, but also looking at the proportions are changing. Non-EU proportion of share of citizenship acquisition in 2011 was 96%. In 2018, that's 52%. And it is also interesting to note the most common nationalities that spread from 2014 to 2018. So it's Poland, Romania, UK, Latvia, Hungary, and Lithuania as well there. So we'll look at the next, moving on, we'll look at the conditions for naturalisation. So these are placed in the Irish Nationality and Citizenship Act of 1956. So under this, the applicant must be over 18 or a child born in Ireland, be of good character, have 5 years residence, intend to continue to reside in Ireland, and declare fidelity and loyalty to the state, take an undertaking to observe laws and respect democratic values. So interestingly, while these conditions are in place, citizenship is not a right. It is frequently described as an honour and privilege by ministers for justice, particularly Charlie Flanagan in previous parliamentary questions. So it is important that there is absolute discretion in this area, despite if people do fulfil all these characteristics. So we'll move on to look specifically at the residence requirement. So in Ireland, a person must have 5 years legal residence out of the previous 9 years. So this is interesting in comparison with other, that's on my next slide. But so just important to note, this is the idea of a reckonable residence. So this is dependent on different residence permissions. For student permissions aren't counted in this, and time spent as an asylum applicant will count if that person gains refugee status. Important to note that this does not apply to subsidiary protection, and the distinction there is because of the declaratory nature of refugee status as opposed to the permission granting of subsidiary protection. So the residence requirement is reduced for persons from a refugee background, spouses or civil partners of Irish citizenship, or children whose parents have naturalised. So this decreases to 3 years out of the previous 5. So of course a quite known issue in Irish citizenship over the last year is the idea of this final year being continuous. So the Jones versus Minister for Justice and Equality case kind of created a bit of a tumultuous time in this area, as the High Court held that continuous must mean unbroken. This was later appealed and overturned by the Court of Appeal, stating that that idea was unworkable and unrealistic. But they did actually uphold the 6-week absence policy, which was being challenged by the applicant, saying that it was reasonable and it did give sufficient flexibility for applicants. NGOs and legal practitioners welcomed this decision of overturning the High Court decision, but also asked for more public guidance to be made available on the application of the 6-week rule and whether discretion existed in that area. So next we'll look at this comparing with the EU requirements. So residence periods range from 3 to 5 years. Ireland is quite in line with other EU member states with requiring 5 years. In addition, permitted absences vary. Ireland is quite, I suppose, middle of the road in this situation as well. In Cyprus, no absences are permitted in the year prior to application. The UK has a kind of different system of allowing 90 days in the year prior, but that the total absences can't amount to more than 450 days. And then Belgium does not require continuous residence. Absences are permitted up to 6 months, as long as the applicant isn't absent for more than 1 continuous year within the 5-year period. So next we'll move on and looking at the good character requirement. So this is not defined in legislation or policy. No guidance has been made available, and the factors which can be considered are within the total discretion of the Minister and the Department of Justice. And the GNIB are the primary source of information on this. Applicants are required to provide information on convictions and otherwise. So the department has noted that failure to show good character is among the top reasons for refusals, and this has been a major focus of recent judgments. Important to note that Uresco, who was a minor, this concerned a child who was applying for citizenship but was refused because of her father's previous convictions. And it's important to note, while the parent is procedurally the applicant, the conditions are assessed on the minor's conditions and good character. Similar, or I suppose this issue with the good character requirement is often described as coming to the attention of the Gardaí. This was raised in I, who was actually a witness in a criminal investigation, which was overturned. The decision to refuse was overturned there, and Tala versus Minister for Justice and Equality noted that the rationale for looking at nature of offences is primarily of importance rather than, I suppose, the existence of an offence. So that was in relation to a road traffic accident, a road traffic conviction or fine on that situation. So NGOs similarly have asked for more clarification and guidance on this. So we'll look at the next slide where this is actually available in the UK. So the UK Home Office public guidance is available on assessing character. So this assists applicants in this area. And also in Portugal, there are more specific guidance on what is required or what is an issue for applications in this case if a person has been convicted of a sentence of imprisonment for more than 3 years. 16 member states require submission of a copy of a criminal record or statement from your country of origin, which Ireland does not do, and applicants are also assessed for tax compliance in 6 member states and the UK. So moving on, we'll have a look at the the idea of an economic consideration in Ireland. So this isn't required in Irish law, but interestingly, details of employment and social welfare are required in a naturalisation application. There's no specific guidance on what details these require or how persuasive they are in an application, but it has been said that forms consideration of the overall application. In 13 EU member states, they have some form of economic requirement. So independent means of support in Germany, Denmark and Austria, proof of an income, which also includes social welfare in Estonia and Finland, and it's taken into account in this broad idea in a similar way of Ireland in Cyprus, France, Greece, Italy and Slovakia. So we'll just move on to the next on the process of, or the language and integration, apologies. So Ireland, in a recent study taken by Ireland with the Department of Justice, it's important to note that there are different considerations that need to be taken into account in introducing these requirements. Ireland is one of 3 member states that doesn't require a language proficiency test, and Ireland is one of 9 member states which would not require knowledge of society. This is a policy that's been examining whether it should be changed, and as I said, it's an interesting read, the report that's available on the EMN website on this matter. So we'll just move along on to the next slide, and the process for applying in Ireland is paper-based. In other member states this is online application or via email, and interesting to note, Ireland is among one of the highest fees, has one of the highest fees for certificate of naturalisation at €950 in addition to a €175 application fee. The certification fee is reduced for children and widowers and waived for refugees and stateless persons, which has been recommended in human rights obligations. So as I said, Ireland is among 4 countries charging the highest fees for application and certificate, and we'll move on just to the next slide there. Yeah, so processing times in Ireland and the EU. So Ireland, the department has said in 2019 that straightforward cases would take about 6 months. This has increased to 12 months in 2020, partly in fact to COVID-19 and also due to the backlogs created following uncertainty in the Jones versus Minister for Justice case. But NGOs routinely have flagged that applicants are routinely waiting more than 12 months. The Irish Times broke a story last week discussing that 5,379 applicants are waiting over 2 years. This is an issue that's also in the EU member states, despite maximum limits being set in Austria and Belgium, and to 6 months and to 48 months in Italy. These limits are there, but they aren't being met. So this is a problem in many EU states as well. So we'll just move on finally to look at the citizenship ceremonies. So these were introduced in 2011 as a mandatory element of the process in declaring fidelity and loyalty to the state, but they're also, I suppose, a celebratory element of the process as well. They're usually presided over by a judge and attended by the minister. Because of COVID-19, virtual ceremonies were piloted in 2020. However, in October, these have been replaced with a signed affidavit in balance of the delays and backlog that is being met to try and, I suppose, pull resources that way, is the statement given by Minister McEntee. So similarly, 21 EU member states and the UK require a declaration of loyalty, and the ceremonies are mandatory in 12 member states in the UK. And in the remaining member states, ceremonies do not take place or are voluntary, and applicants would make a declaration before a national ministry or local authority. So in conclusion, we'll just have a look over the points made. Yeah, so overall, a decrease in people acquiring Irish citizenship, a slight increase in EU nationals in recent years, and it also begs the question of perhaps why, bar Brexit, why are other EU nationals gaining citizenship in Ireland if given the, I suppose, equal rights in terms of EU. So it obviously may have some links to integration outcomes in that area. In comparison with other EU member states, Ireland's naturalisation procedures and conditions are favourable. Efforts to promote citizenship through ceremonies have been welcomed, and hopefully in a post-COVID world these will be able to resume. But in addition, challenges still face applicants, particularly in the lack of guidance and clarity in conditions, particularly in relation to permitted absences and good character requirements, and also processing times and fees are frequently raised as a concern in this area. So thank you all for listening, and I look forward to your questions.
Thank you very much, Roisin. So first we've had an overview of key academic debates, and then we've had details on the pathway to citizenship through naturalisation, the pathway and the challenges that Roisin outlined. You'll notice, particularly the international speakers, it's hard, of course, in these days to talk about anything in Ireland without mentioning both COVID-19 and Brexit as two particular challenges, current challenges for Irish society. But once again, I'd ask you to put questions in the Q&A, please, for both talks. But we'll move on now to our next speaker, Catherine Cosgrave. Catherine is Managing Solicitor at the Immigrant Council of Ireland Independent Law Centre. She's a specialised migration and human rights lawyer here in Ireland and the author of several leading publications relating to family and child migration, human trafficking and citizenship. Catherine is the EUDO Ireland country expert on citizenship and sits on the advisory committee of the European Network on Statelessness. Catherine is also the Fundamental Rights Agency Network Ireland expert on migration. She's going to talk about some recent developments in Irish citizenship from her perspective. Over to you, Catherine.
Good morning, Fran. Can you hear me?
Yeah.
Great.
Sounds good.
Good morning, everybody. Thank you very much to the EMN for the invitation to participate in this morning's conference. And first and foremost, congratulations to the EMN and the previous speaker, Roisin, and the other authors on the publication yesterday of the very comprehensive, accessible and extremely timely report. I've been requested to provide a short input this morning on the recent developments regarding citizenship in Ireland, and I suppose at the outset I just want to acknowledge that the time wouldn't permit me to give a comprehensive in-depth update in that regard. So just to note that very many of the relevant updates are in fact detailed in the EMN report as published yesterday, but also in a very recent paper delivered by Sarah Moorhead, Senior Counsel at the Immigration Bar Association conference last week. I'm not sure if that paper is available online, but it gives an interesting overview of some of the critical case law in the area. By way of introduction to myself, I'm the Managing Solicitor at the Immigrant Council of Ireland. It's an NGO and independent law centre based here in Dublin, and we provide a number of services, including first and foremost a helpline to the public and a legal service through the law centre. And just by way of context, I suppose, to this morning, I thought it might be important to note that since our establishment in the early 2000s, queries related to citizenship, or indeed more particularly security of immigration status and establishing permanency in Ireland by way of either access to long-term residence or citizenship, are consistently the highest numbers of queries received in the Immigrant Council Law Centre every year. So just for context there, in 2018, our stats were not recorded properly, but out of those that were recorded, there were approximately 22% of them related to citizenship. So a total of 797 queries that year. The following year, that had increased to 987, or approximately 20% of all queries received. And then last year, or rather this year, our stats haven't yet been totaled, but again, we can see that the queries are currently, as of last week, 956 queries out of a total of just over 5,000, and approximately 18% of queries overall. And that's perhaps not all that surprising in terms of the level of interest by migrants and our service users in the issue when we look at the demographics and particularly the census population, most recently compiled in 2016, and specifically the census report on migration published in 2018. where we see that there were just over 500,000 non-Irish, representing over 200 different nationalities living in Ireland. But interestingly then as well, 12.3% of non-Irish nationals aged 0 to 14 are non-Irish nationals. So that it reflects, I suppose, the interest in this issue coming through the service. The existing research and direct engagement with migrants in the Law Centre does reveal to us, and I suppose it echoes Maarten's own contribution earlier this morning in the keynote, that migrants often have several motivations for applying for citizenship in Ireland. However, in my experience, an almost universal reason for applying is to counter the lack of security that is experienced by migrants arising from only having temporary residence status. Many of you will be aware that residence permission is frequently only granted for short periods of 12 months and is required to be renewed. And I suppose I just take the opportunity to note, when we discuss the conditions to be fulfilled, in particular the 5-year reckonable residence criteria, many people take that at face value and assume that people can apply after 5 years, which is of course correct in some instances, but it can actually take many years longer than that 5 years on the face of it for individuals to actually achieve the 5 years reckonable residence because of the gaps that may arise through no fault of the applicant trying to renew their permits and keep on top of that in a timely fashion. So many migrants report that becoming an Irish citizen may give them opportunities to contribute further to Ireland, that they would be less restricted in the type of work that they could do, particularly if they are employed through employment permits, but also that they have a wider sense of belonging to the community and wish to participate more fully, including having the right to vote. Issues related to identity and belonging are also especially acute for children who access our service, particularly those who may have been born here but are not entitled to automatic citizenship at birth, and foreign-born children who may have resided in Ireland for a very long time, including children who have been received into the care of the state and who may have had very limited or no contact indeed with their birth families for years. Queries received into the service cover the very broad spectrum of Irish citizenship matters, including naturalisation by both adults and children born in Ireland, but also children born abroad. Queries relating to the reckonable residence to be fulfilled by parents in order for their children to acquire citizenship at birth, and then finally citizenship by descent, which would have had an increase in recent years, particularly from British nationals in the context of Brexit, already mentioned. The queries outside of that very broad content, they relate very much to what I would describe as two different areas. Some are very administrative in focus. Which application form should a person use? What are the required?
Excuse me, could you just indicate when the slide should move on, please, just so that we're looking at the right slide?
Sorry, because I have moved them on, Fran. So it's on the slide just saying nature of queries received, administrative and substantive. So it's probably, yeah.
Yeah, that's it. Okay, yes, just to keep an eye on that, or indicate next slide. Yeah.
Perfect, no problem. So as I was saying, the queries that we receive are broken down into administrative queries on the part of applicants. Which form should they use? What is the nature of the required supporting documents, the application procedure, processing times and whatnot. And then more substantive queries relating to the interpretation of the statutory criteria or eligibility criteria that Roisin outlined in her presentation, the reasons offered by the Minister when refusing an application, if indeed a reason is provided, and administrative and judicial review of applications that are refused in the absence of an appeal procedure. Most recently, issues related to proposed revocation of citizenship granted by naturalisation, and then much more contentious issues related to stateless determination and accessing nationality where a person doesn't have any form of nationality already established. In terms of preparing for today, sorry, next slide, please, Fran. I thought that it would be interesting just to undertake a slight retrospective, if you will. It's an area that I have been working on for a number of years, and Roisin's presentation, I suppose, summarised some of this quite nicely. But when I look back at a piece of research that the Immigrant Council undertook in 2011 and documented quite a lot of issues at that time, I suppose some of the findings indicated that we had very low rates of naturalisation, very high application fees. There were excessive processing times. At that time, it was not uncommon for people to be waiting 3 to 4 years routinely for a decision, and that there were commonly very disproportionate reasons offered for refusal relating to the issue of good behaviour, very high threshold and no appeals procedures, and the lack of celebration offered to individuals who were granted citizenship. Next slide. I suppose it's welcome then to note today, in terms of a very macro overview of developments that have taken place, that while we may still have high fees and no appeals procedures, there are nonetheless positives to be noted, namely the higher rates of naturalisation overall. It's documented in the EMN report. And I suppose to acknowledge improved customer service and processing times, the INIS has overhauled the relevant website. It's far more accessible and user-friendly. And processing times had, broadly speaking, come down dramatically, but there remain challenges arising from, as Roisin mentioned, the Jones case, and then more recently the COVID experience, as I call it, which has severely impacted on processing times. And then the very welcome introduction in 2011 of the citizenship ceremonies, which I think have been broadly and universally welcomed by all. But I want to now turn very quickly to more recent specific updates, of which there have been very many. Including not only in the context of judicial developments, which have been touched on, as I say, by Sarah Moorhead in her paper last week for the Bar Association, but also in Roisin's presentation already. There have been a number of very, very significant cases. Dimash there touching upon the contentious issue of revocation of Irish citizenship once granted by naturalisation, the case of Urescu already mentioned by Roisin regarding who is considered to be the applicant to be assessed when the application is made on behalf of a child. Is it the parent or is it the child? And the court concluding that it is the child who is the subject of the application that must be considered. And then Jones, which I'll come back to in just a minute, but other very important cases were that of EMN looking at the criteria to be assessed when looking at good character, and then finally the case of Borda against the Minister for Justice, which touched on the issue of children applying as siblings of Irish citizens and being refused their application on grounds of association, while the Minister acknowledging that they had Irish associations, deeming that they weren't sufficiently close an Irish association in order for naturalisation to be granted, and the court setting aside that decision on the grounds that the Minister was obliged to give reasons for why the individual wasn't deemed to have close enough of an association. And this was felt important in order for the applicant in the case, but also I suppose other applicants, to actually have a sufficiently clear insight as to when their application might likely be granted, or how they could rectify any perceived deficiency in their application if they were to reapply. These are all very important cases, and I'm happy to take questions later on them, I suppose. But the one from a service user's perspective that really impacted our service users was that of Jones regarding the continuous residence requirements in the 12-month period prior to making applications. As Roisin noted, I think the decision of the Court of Appeal was broadly welcomed after the consternation caused by the High Court judgment that predated it. And while it provides some clarity regarding the reasonableness of the 6-week rule, it is probably nonetheless, I suppose, urged that further clarity and guidance would be published regarding this. In particular, what exceptional circumstances are allowed in order to be outside of the state for more than 6 weeks, or where people are required to undertake significant levels of work-related travel. The decision takes us back to the practice that has been established pre-July 2019, I suppose, but it doesn't give a lot of clarity, and also the department provides no guidance regarding the Citizenship Directive and the residence entitlements of EU citizens and their family members, regardless of nationality, who have very strong entitlements to be outside of the state pursuant to the Citizenship Directive without having been deemed to lose their residence. So it is an important, all of these, I suppose, are important rulings with regard to the Minister's obligations when conducting assessments in respect of applicants, but it remains to be seen, I suppose, whether they will result in a significant shift in policy with respect to how applications for naturalisation are considered. I've already mentioned the fact that there isn't a statutory right of appeal against refusals to grant citizenship, and in this regard, it's noteworthy, I suppose, that many of these developments are taking place in the context of litigation, which is welcome, where obviously clarity can be provided on points of law, but I suppose I'm interested in these cases because of the fact that I can see in practice that they do lend themselves somewhat to a lack of consistency and transparency in terms of application. In the absence of an appeal or indeed going to judicial review, the department will on occasion consider applications for a review of a refusal on an administrative basis, where some of these issues have been dealt with and decisions have been set aside. And so I wonder not only about the lack of published guidance in this area, but at what point there will be implementation of these judgments by way of either published policy guidance or more particularly legislative reform. In terms of additional developments, there have been notable administrative changes. Sorry, next slide, Roisin, or not Roisin, Fran. Some of which have been touched on again already, in particular the impact of COVID-19 on the INIS operations, giving rise to a backlog and increased processing times. But against that, I think it's fair to acknowledge that the department has really been conscious of this, I think, and trying to communicate efforts that have been made this year to introduce procedures, including e-vetting and tax clearance, to speed up the process and also to finalise the process for applicants who had already been notified of positive decisions, and the provision of a virtual ceremony, and now further efforts to introduce a statutory declaration so that people can complete the procedure. But very recently, I suppose, there has been much more of a conversation arising partly from the level of case law in this area, I suppose, but a broader understanding of the need for reform in this area, and there have been some legislative developments, although not yet enacted. It's acknowledged, I suppose, by many that the principal act underpinning access to naturalisation dates back to 1956, when Ireland experienced little of any inward migration at that stage. And it has prompted discussions for a number of years now. Indeed, it had been on the agenda of the Law Reform Commission at one stage to undertake a review and perhaps a formal consolidation, as well as comprehensive reform. It's been the topic of very recent discussion, particularly with respect to access to citizenship at birth, or for children who have born in Ireland who are not entitled to citizenship at birth. And just last week, Labour had a bill before the Houses of the Oireachtas, which had first been published in 2018. Next slide, Fran. The bill is entitled the Irish Nationality and Citizenship Naturalisation of Minors Born in Ireland Bill 2018. It's currently at third stage before the Houses of the Oireachtas. It was the matter, in my view, of some wildly inaccurate discussion in mainstream and on social media, but also in the Houses of the Oireachtas itself, with respect to references being made to this bill providing for birthright citizenship and seeking to provide a remedy for stateless children. And that is in fact actually not correct. There would already be a remedy on the statute for any child born in Ireland who is a stateless child. And while accessing the remedy might be a little bit difficult in the absence of any published guidance regarding Section 28 of the Act, or indeed a stateless determination procedure, there is in theory a remedy. So what does this bill propose? The bill doesn't seek to restore automatic birthright citizenship to children born in Ireland. Rather, it permits applications for naturalisation to be made for children born in Ireland after 2 years who wouldn't qualify otherwise for birthright citizenship. And that's currently only provided for, as Roisin mentioned in her presentation, where one parent is either Irish or one parent fulfills reckonable residence. And currently children born in Ireland aren't entitled to birthright citizenship, can apply for naturalisation on fulfilment of the 5 years reckonable residence criteria. Under this Labour bill, if it was enacted, it doesn't mean that children would be entitled to be granted naturalisation either. They would just be eligible to apply, and thereafter it would be granted at the absolute discretion of the minister. So if the legislation was enacted, it will be very interesting to see the approach taken by the minister with respect to such applications, especially in respect of children whose parents are not currently lawfully resident in the state, as children are deemed to derive their residence in Ireland through their parents first and foremost. In addition to the Labour bill, there's also a bill, next slide, that has received less attention, was published by Mick Barry TD, entitled the Irish Nationality and Citizenship for Children Bill 2020. It proposes different amendments to the law than that are provided for in the Labour bill. It provides first and foremost for automatic citizenship at birth for children born in Ireland. It then goes on to provide an entitlement to citizenship for children residing, or more particularly living in Ireland, for 3 years. So there will be no requirement to fulfil reckonable residence criteria in those cases. It also seeks to amend the current Section 10 of the Irish Nationality and Citizenship Act by providing that foundlings, namely children who are abandoned, perhaps, so foundlings to be deemed to have been born in Ireland without any requirement, as is currently provided, to assume that one of those, the parent of a foundling is an Irish citizen. So therefore, if enacted, they would automatically get citizenship at birth. And it also seeks to amend the Section 16 definition of Irish associations to include siblings of Irish citizens. And I suppose this is a bill that is seeking to give effect to the Boarta decision that I just mentioned earlier. Next slide. So Mick Barry's
finish
bill,
up,
goes,
Catherine.
what,
Yeah.
Hello?
Hi, can you finish up now? Just the time's up. Yeah.
Yeah, I'm just about.
Oh yes, oh I saw the thank you.
Yeah.
Thanks.
So I suppose just to conclude, Mick Barry's bill there goes much further than the Labour bill by firstly providing automatic citizenship at birth after 3 years, and there's probably some merit to the other provisions regarding foundlings and Irish associations. Just to conclude, I suppose the focus of my presentation has really been from the outset to look at what motivates people to apply for citizenship. And certainly my experience indicates that that is largely predicated on the fact that it's very difficult currently for any foreign national, but particularly children, to gain any form of permanent resident status in Ireland. And particularly for young people to not only have resident status, but an appropriate resident status that gives them access to, for example, the labour market, including during their teenage years, and to obtain experience just like their peers would, particularly where they're very long stay in Ireland and in the most part lawfully resident also. There remains no provision in the Irish immigration system presently for granting this status, and in lieu of granting appropriate residence permission, individuals are seeking to achieve that through citizenship. And I suppose, given the level of litigation that we have witnessed in recent years, I conclude just by saying I think that the case has been made that there's really a need for reform arising from all of these developments for outdated legislation underpinning access to Irish citizenship to be looked at and reformed comprehensively. Thank you very much.
Thank you very much, Catherine. It's very valuable to have a legal and a practice perspective. I mean, just for the for international participants here, I think it goes without saying for an Irish audience, but Ireland in the 1950s, 60s, 70s and 80s was a country of emigration, sometimes significant emigration, and that in a sort of broader scale, Ireland is is new to the party in terms of the inward migration of non-Irish nationals, which really started rapidly increasing in the early 1990s as part of the Celtic Tiger boom. So now we've learned a lot about the Irish experience from Roisin and Catherine. We're now going to turn to Finland. I'd now like to welcome Tuukka Lampi, who is the Senior Specialist at the Finnish National Contact Point of the European Migration Network. Before joining the EMN, Tuukka worked at the Nationality Unit of the Finnish Immigration Service, and before that with the IOM, the International Organization for Migration, and the Finnish Embassy in New Delhi as an immigration officer. Tuukka is going to talk about pathways to citizenship through naturalization in Finland. Okay, Tuukka.
Thank you, Fran. And greetings from Finland, and thank you for having me in your conference. Let me just get my slides over there. And oops, can you see them?
Yes, yeah.
Okay, great, thank you. Yeah, so in my presentation, I will first go through an overview of citizenship in Finland, and then I will move on to some of the requirements for third country nationals for naturalization in more detail, and then I will conclude with a brief discussion on our national report findings regarding naturalization and integration in Finland. Starting off with some of the rights that are provided by Finnish citizenship. As in many other EU countries, they mostly have to deal with political representation and agency, as well as international mobility. And then some of the obligations, on the other hand, have to deal with assisting in national defense, as well as complying with Finnish laws, not only in Finland, but also outside of Finland. A quick statistical overview on the Finnish citizenship applications. As you can see from the last 5 years, there have not been very dramatic fluctuations in the terms of quantity of applications. If anything, we can maybe observe a slight rising trend, and this is probably something that can be expected to continue in the near future as well. On the red line, you see the amount of rejected applicants, and the rejection rates generally have stayed fairly steady at around 15%. And each year. Some more numbers, top 5 applicants, top 5 nationalities applying for Finnish citizenship in 2019, and then also below you see the applicants who were granted nationalities who were granted Finnish citizenship in 2019. And as you can see, there are slight differences in who applies for citizenship and then who is granted citizenship actually. Number 1 in last year was still Russia in both categories. From this, and has been historically for a long time, but this year actually there was a slight change because Iraqi citizens became the number 1 nationality applying for citizenship, which was an expected statistical trend considering that so many Iraqi people arrived in 2015, and they had now stayed the minimum period. Some legal context. Finland is, of course, party to the main international legal instruments regulating citizenship, the UN Convention on Statelessness, as well as the 97 European Convention on Nationality. Then more on the national level, the Finnish Constitution mentions briefly only that the Nationality Act is the one that regulates all the aspects of Finnish citizenship. And then there's the Nationality Act, which features all the legal nuts and bolts of that has to do with nationality. And then there's the government decree on nationality, which lays out some of the responsibilities of different authorities that have to deal with naturalization. And then I've listed a few acts which are also relevant in naturalization by proxy, such as the Administrative Procedure Act, Then there's the Aliens Act regulating aliens' legal residence in Finland, and of course, Passport Act. Recently, there have been some amendments in legislation, which have been mostly a result of public discussion on citizenship, mostly dealing with national security and crime control. For example, in April 26th, the new law came into effect, which allowed the revocation of citizenship based on certain crimes, such as terrorism or treason or other equally severe crimes. And then later on the same year, some restrictions were passed on dual citizens in certain public posts, such as mostly to deal with military and border guard. However, there were some concessions as well. There was an amendment to the Maternity Act, which facilitated the female same-sex couples' ability to pass Finnish citizenship to their children, because earlier they had to resort to intra-family adoption. So this now enabled them to pass it directly. So speaking of passing of citizenship, how the Finnish Nationality Act mostly observes the principle of jus sanguinis, that is citizenship by birth. I have added here the section 9 of the Nationality Act, which shows you that mostly or primarily the citizenship in Finland is passed through one's mother, but can also be passed through the father with certain caveats as listed here. Mostly the father has to have some relation to the mother. However, in some cases, the jus soli principle can also be used. These are mostly cases that deal with preventing statelessness for children. So if there's a child born in Finland, they can acquire Finnish citizenship in certain cases, such as in cases where the parents' citizenship is not known, or if for a political or a technical reason the citizenship cannot be passed to the children directly. I have also added such as an interesting detail, the jus originis principle, which is basically right to acquire Finnish citizenship through your connection to the former connection to the country. So just say that there's also the provision for former Finnish citizens to acquire citizenship through an expedited process or a quicker and simpler process. Moving on to the main requirements for third country nationals to acquire Finnish citizenship, there are the 5 building blocks of citizenship or naturalization, and I'll go through them all in more detail. Starting from the period of residence, as in many other EU countries, Finland also demands a minimum period of residence. It's either 5 years without interruption, or 7 years if there are gaps in between. But even out of those 7 years, the person still has to have stayed in Finland for the last 2 years without interruption. And certain groups have concessions, such as refugees, who also only have to stay for 4 years or 6, respectively, or spouses of Finnish citizens who also have the same benefit. And I also added Nordic citizens who only have a 2-year minimum period of residence, but that is of course slightly off topic. Another very important aspect of naturalization in Finland is the language requirement. As in many other EU countries which have a language requirement, the minimum level is B1, and you have to prove it in either Finnish language, Swedish language, or Finnish Sign Language or Swedish Sign Language used in Finland. And your language skills can be proven with a host of documents or certificates which are listed in the Nationality Act, more detail. Most common is the National Language Proficiency Diploma, which most applicants usually use. It's basically a language test and a diploma. Of course, there are certain groups which can be exempted partly or fully from the language requirement. These are illiterate people, or elderly people with refugee status, or people with severe health impediments. However, it should be noted that illiterate people or people with health impediments, in these cases, the exceptions are made very rarely and only with very solid proof. Elderly people, whereas with elderly people, it is by default. Good conduct is also an important aspect of the citizenship application. This refers to on overall assessment of the applicant's crime record, and if there are crimes, if there are crimes on it, then what is taken into account is how much time has passed from the crime, what is the severity of the punishment, what was the nature of the crime, and whether the offenses have been recurring. So if you have a speeding ticket or a parking ticket, that doesn't necessarily prevent you from receiving Finnish citizenship, but if you have dozens or hundreds of speeding tickets and you have shown no interest in paying for the fines, that might already affect your case. And based on the assessment, also there can be a waiting time issued, during which your application or you will not be granted citizenship. But after the waiting time has passed and you have mended your ways, then your case might be reconsidered. And also part of good conduct is also not having any unpaid fees chargeable under public laws, such as unpaid taxes or fines. Part of the application process is also reviewing the applicant's income for the entire period of residence. This has less to do with whether the person has a job or they have whether they have sufficient income. Rather, it is more of a review of the person's economic activity, and it's connected to the period of residence requirement. So basically, what is looked at, whether that the person has had consistently some economic activity, be it salary, be it entrepreneurial activity, or even benefits given by the state throughout the whole minimum required of residence. So it is another way of confirming that the person has actually stayed in Finland. Then one of the most important aspects of processing an application is established in the applicant's identity. Now, because the citizenship application cannot be processed if we don't know who is actually applying for the citizenship. Generally, an applicant is, of course, obliged to present valid identity documents, such as a passport, as part of the application process. But in many cases, this is, of course, is not possible because people, for example, refugees may not have any identity documents, or they are unable to acquire them, or their country of origin, the identity documents from their country of origin are not considered reliable enough as such. So in those cases, then it becomes an overall assessment of the person's personal data for the whole, their whole sojourn in Finland, and sometimes also even beyond that. For example, in cases where they might have given certain information in the Eurodac system, and then they might have given other personal data in Finland, that might be something that affects the case. So lack of documents, falsified documents, and inconsistent personal data are constant challenges in processing citizenship applications in Finland. And I've listed here the top 5 grounds for refusal of citizenship application. And this is from 2018 because those were the statistics available at the time. But from experience, I can say that most likely this is the order remains the same, because this has been the order for some years now. Inadequate language skills being the #1 reason for refused applications. So then if you do receive your Finnish citizenship, since 2003, you no longer have to give up your former citizenship, because Finland now, since 2003, has allowed dual citizenship. The motivation for this, or allowing this originally, was to firstly to stay better connected to the Finnish diaspora abroad, but also encourage foreigners living abroad, foreigners living in Finland, to apply for citizenship more actively. Of course, dual citizens, as I mentioned, have some restrictions. For example, since July, they are restricted from certain public offices, and as I mentioned, these are mostly to do with military and border guard. And it has been a part of this has been a result of public debate regarding concerns about national security and foreign attempts to influence Finnish dual citizens, which has been a heated topic of debate as well. Then moving on to citizenship and integration. Based on our EMN report and our conversations with Finnish authorities, it seems that the acquisition of citizenship has been viewed as sort of a step in the integration process, and there has been no direct connections between naturalization and the promotion of integration. But this is not. It doesn't seem to be defined very clearly in current, on state level. I've added a timeline here from 2010 to 19. As you can see, still in 2010 up to 2015, naturalization was still mentioned in the immigration, or on the integration policy agenda somewhat. But the 2016 to 19 integration plan, which was referred to in our EMN report, already had no connection between naturalization. I did not mention naturalization and integration directly at all. But at the same time, on the same note, it could be mentioned that there's been very little research made actually on this topic in Finland. So it still remains a bit of a uncharted territory.
Okay, could you please conclude?
Yes, this is my last slide.
Oh yeah, that's your last slide. Okay.
Yeah. And so, but as a but if you, after receiving your Finnish citizenship, based on our EMN study, it seems that one gets very little targeted support, since there's a, and you receive basically it's a very fairly simple process. When you have been granted Finnish citizenship, you receive a short letter, either on the web service of Immigrant or by mail, which simply unceremoniously in 2 sentences states that you have now been granted Finnish citizenship, and there are no naturalization ceremonies, at least on national level, and no official demands for committing to Finnish values or loyalty as such. So no symbolic gestures as such. But in some local level in cities, they have organized Finnish naturalization ceremonies for new citizens. And some cities have also provided perks for new citizens, such as free tickets to events and things like that. But on a national level, it still remains. Or there is no concrete policy to support new citizens. But on a final note, at least I can mention that it has been now on a topic of current public discussion, whether Finland should also acknowledge and celebrate their new citizens more actively, and that remains to be seen. So thank you. That is all from me.
Thank you very much, Tuukka. It's very interesting to hear about the situation in Finland. In fact, thank you very much to all the speakers for such food for thought. We're now going to move to the Q&A session. I think what I particularly enjoyed about the session is the variety of methods that were discussed, be that case law or experiments, longitudinal research, policy analysis. So it's an unusually broad range of both topics and issues within the debates on citizenship, but also methods. So now a number of people in the Q&A have asked about their own particular situation or their own application from a sort of personal point of view. We'll not take those here in this Q&A. Perhaps people could get in touch with, say, Catherine Cosgrove at the Immigrant Council of Ireland Law Centre, or with the Department of Justice for those specific questions. But turning on to more substantive questions now about the issues. One question I've seen here for Professor Vink is about the Swiss case, from the questions from Zakaria Sahir. She said, thank you very much to all the speakers, very interesting and stimulating talks. The question here is about this use of the experiment and the people who barely won, if you like, in the referendum and barely lost. To what extent, the research showed that those who benefit more from this are marginalized migrants from Turkey and Yugoslavia, but the question is raised, they're very big groups in Switzerland, and also they're marginalized. So I suppose the question then for Professor Vink is, to what extent is the citizenship premium, is that linked to both the size of the group potentially, but also whether they're marginalized? This could be framed perhaps as a broader question that I'm interested in, about evidence on who experiences the biggest premium, if you like, which citizens have most to gain. He touched on that a little bit in his talk, but maybe if he could, Professor Vink could talk a little bit about that now, please. Remember to unmute yourself when you're speaking. Yeah, okay.
Thanks a lot, Fran, and it's an excellent question, Zakaria. Indeed, when we talk about causal effect, there are many things that may complicate this, right? So if you're interested in this, I certainly invite you to read the paper by the Swiss colleagues. As I said, it's open access available. I also appreciate that, of course, it gets rather technical, and once we get into the nitty-gritty of the design. Maybe I say something about the Swiss case and then something more general relating to Fran's question. So what happened in the Swiss case, that there is this referendum, right? And we use that to, in a way, randomize treatment. The treatment here would be the citizenship acquisition, in order to determine whether it's really the citizenship that matters or some kind of underlying factor that we cannot measure. And I think Zakaria makes an excellent point that, of course, there's a lot of heterogeneity going on. Some of it we can observe with characteristics of migrants, others not. Keep in mind here that in the Swiss case, what the authors indicate is that voters who had to decide about these citizenship applications, they received a leaflet containing detailed information about each application, including the name of the applicant, the origin country, gender, age, length of residency, and language skills. And so the kind of characteristics that Zakaria referred to in terms of whether there were any effects of visible minorities within the Turkish community, I'm not sure whether that can be deduced from the application. Secondly, of course, the crucial part of the Swiss design is to look at those who barely win and barely lose, right? So 45 versus 55% of the yes votes, and the others, if there would be very strong visible differences which would be available to the voters, we would expect maybe bigger effects of this in the range of, the difference between a German making an application for naturalization in Switzerland and a Turk making an application, where the differences between yes and no votes would be much larger. So the authors argue that because they look at these narrow differences, yeah, the differences between yes, no will be determined by random factors such as the weather on the day of the vote, or whether the vote aligns with another referendum that people may be particularly interested in. So accidental factors that are not relevant to the actual application, and that's why it allows the authors to identify this randomized effect. So as I said, that's a very neat design. Yeah, you could say the downside is that it's not so easily replicable outside of this idiosyncratic Swiss design, right? But it certainly allows us with a different way to say something about the causal effect of citizenship, and it, if anything, it aligns with research findings from other designs, such as those based on longitudinal designs. First of all, maybe a short word on what Catherine said. I think that's also really important, that when we think about catalyst versus crown, the crown argument is often, well, citizenship doesn't add much to permanent residency. But I think what Catherine said is an excellent example that actually citizenship does matter for security, right? And this may be actually the primary interest of migrants. That's what we often hear about from migrants in qualitative studies, and I hear that also in the Netherlands, where there is still very access to permanent residency may be more facilitated than in Ireland. And so that I think is really important also from this perspective of anticipation, right? So for migrants, this is often a symbolically a very important moment, and that also allows them to see their own future in the destination country, and that I think also helps migrants to invest in their own human capital development. On Fran's question, so what kind of effect heterogeneity we see between migrant groups, right? First of all, I should say that between the literature, it depends a bit on the study. So some studies look at EU versus non-EU. Other studies, like here in the Swiss case, that look at marginalized groups, so Turks and Yugoslavs. We in our work in the Netherlands have also looked at development level of the origin country. Others have looked at origin regions around the world, so Africa, Southeast Asia, Latin America. So actually, the first answer to your question is that the picture is a bit diffuse. I would say the specific picture is a bit diffuse, but I would say the big picture is quite clear, that it's really about EU versus non-EU, or we could say well, privileged migrants versus less privileged migrants, and less privileged can be measured by origin region, level of development, or zooming in on specific origin groups, but that doesn't actually change the picture of what we find much, namely that citizenship matters most for those migrants who face the highest constraints in obstacles in the destination context, in the labor market, and also those migrants who actually are most interested to naturalize, right? And that also means that if we impose extra obstacles, hurdles, fees, waiting time, naturalization requirements, we also see that translate in actually lower naturalization rates, especially among those migrant groups who are most interested and who stand most to benefit from citizenship.
Thank you, Maarten. That's very helpful. I appreciate, I mean, particularly in this area and in migrant integration more generally, the country context varies hugely, as well as the study. So I think thank you very much for giving that overview. I've got some more questions here. One from Tian Lloyd: to all speakers, some countries disallow dual citizenship. This was brought up in the Finnish presentation, which means immigrants from those countries are discouraged from naturalization. Should countries consider giving more rights to those with permanent residency? I suppose that's a particularly relevant question in Ireland. Does anybody have any thoughts there? Both Maarten and Catherine brought this up.
I suppose, Fran, if I may, it's a particularly relevant question, actually, and it does underpin what I touched on in the presentation regarding the desirability of providing access to permanent residence and rights that accrue over time because of the fact that actually there is no permanent residence provided for under Irish law. We don't participate in the long-term residence directive, and the long-term residence that we do provide for on an administrative basis isn't open to all foreign nationals to apply for, but it also does not equate to permanent residence in the sense that it is provided for under the long-term residence directive or indeed the citizenship directive. So generally where that is provided for in member states, permanent residence is permanent residence, and many rights are provided for that are simply not provided for in Irish law. So we find ourselves in a situation here in Ireland where individuals may find that access to citizenship is the only way that they can, for example, gain access to the labour market. This is a particularly critical issue for dependent children who accompany migrant workers to Ireland, for example, and in particular dependent spouses or partners who are granted residence on Stamp 3 conditions and do not enjoy access easily to the labour market. While there are some arrangements available through the Department of Business to get access to what is called a dependent spousal work permit, they're quite difficult to access and very unattractive for both employers and migrants themselves. And indeed, individuals who come on employment permits outside of critical skills permits may find that they have to maintain a temporary employment permit and a temporary residence permission for periods of 5, 6, 7 years before they would actually be able to successfully apply for either long-term residence or citizenship. And so it's a critical issue that Tian has raised here, and one that I don't have an answer to. I mean, obviously, particularly for nationals who can't enjoy dual nationality because of restrictions under their own country's law, as opposed to in Ireland where there is no restriction holding dual nationality, they don't wish to apply in some instances for citizenship because it would render it very difficult for them to either perhaps return easily to their own country of origin, which clearly where they may have significant family ties or have other things that they may need to deal with, or indeed wish to return to in the future for retirement, or, you know, as we can understand. So this is an issue, and one that I think needs to be urgently examined, so that, like, you don't find yourself in a difficult position, particularly as a child, where you have to gain access to nationality if your parents don't wish to apply for nationality, or don't wish, or can't, they have applied and have been refused, and you are stuck in a limbo somewhere where you actually don't even have access to a residence permission that would allow you to work, for example, as a school leaver, despite having completed primary and secondary education in Ireland. The only solution is citizenship, and you can't apply as a minor if your parents haven't naturalised. So you find this huge scramble for children, particularly leaving school and leaving care, to resolve these issues.
Thanks, Catherine. Sticking with the Irish case for a moment, Ralph Pittry has some questions for Roisin and Catherine. One, what are the reasons for the good conduct requirement not being defined by law? And two, how can applicants demonstrate or prove their intention to continue to reside in Ireland? And then a third question from Wojtek Baliak, perhaps on that. I wonder, is there any space in Ireland to consider bringing the cost of the application down? I represent a charity working with Polish nationals in Ireland and find the high cost of citizenship a huge barrier for many migrants who may meet the residency criteria but can't afford the application cost. So I don't know, Catherine, Roisin, whether you'd like to address some of those questions.
Sure. Well, just following on from the last question there, in particular raised by a member of the Polish community, the cost, as Roisin noted in her presentation, is one of the highest in Europe. And in fact, like that has been noted previously in things like the MIPEX Migrant Integration Policy Index findings by the Migration Policy Group based in Brussels, doing a comparative analysis as well. They are extremely high, and that would be something that would be reported on our helpline in the office from people who are considering applying, but where the fee is just a barrier for them to do so. In the report that I mentioned in 2011, we made a recommendation as the Immigrant Council of Ireland and also as NASC, who jointly published that publication, for the fees to be looked at, and that there perhaps should be waivers in respect of particular categories. There is a waiver enjoyed, for example, by refugees, but we recommended that there should be particularly waivers in respect of difficult circumstances like victims experiencing domestic violence who might otherwise be eligible and meet the criteria and what have you, and a sliding scale of fees. Right now it's just quite crude. It's either no fee if you're a refugee or this absolutely high prohibitive fee, and so definitely I think there would be merit in looking at that. In terms of the other questions, one, how does a person prove intention to reside in Ireland in the future? It's a good question, but I guess one that nobody can answer. As a matter of practical reality, the only way you do it is by ticking the box in the Form 8, which signals your intention, yes or no. It's as crude as that. In my experience, it's not necessarily looked behind. And indeed, once citizenship is granted, then you are a member of the European community also, and as a matter of law, there can be no restriction placed on you exercising your free movement entitlements as an Irish citizen within the EU. Of course, people are required to file a notice with the embassy saying that they are outside of the state and that they intend to retain their Irish citizenship, which is certainly not something that is required of Irish citizens by birth. So it is an interesting question, and it's not one that has ever arisen in my practice in terms of somebody having a particular query raised by the department regarding their intention in that regard. And then finally, why is good character not defined? I could speculate about this, but you'd have to ask the Oireachtas who enacted those provisions. I suppose a general observation is that this area is characterised by absolute discretion, and perhaps there's a desire not to impose too many restrictions on what might be taken into account when assessing that. But we have more guidance now as a result, particularly of the MNN judgment, which obviously now has put some parameters on the minister in terms of what should be taken into account in a holistic assessment of character, and not just mere allegations or indeed convictions of a criminal nature. So I would say watch this space.
Yes, thanks, thanks, Catherine. Yes, I suppose then there is a trade-off here between conditions being clear, which is certainly valued by applicants and written, but then allowing a certain amount of flexibility to consider individual cases. Yeah. So yes, this notion of EU. Oh, sorry, Roisin, did you want to say something? Far away.
Just in terms of the intention to continue to reside, there is a case, it's from the 90s, it's Mishra versus the Minister for Justice, and in that case a doctor's quality, he was an Indian doctor and his qualifications weren't recognised in Ireland, so the department assumed that he couldn't be intending to continue to reside. This was overturned by the courts. They said that queries will have to be raised, that it's not fair to assume these things. So I suppose it's perhaps based on that, it's been easier to have the tick box exercise and have to query and question people's intentions.
Yes, well. I suppose, so and it's fair to say, that you know, people can have the intention to reside, but their life circumstances change, and you know, they may subsequently leave having acquired citizenship, but it was their intention at the time of application to stay. This issue of sort of EU versus non-EU applications for citizenship, this has recently become a relevant issue in Ireland, because there has been quite a shift. Originally it was mainly the first wave and peak we saw was non-EU nationals, and now there has been a somewhat of a shift to to applications for Irish citizenship from EU nationals. Julie O'Leary asked, does any data exist as to whether certain nationalities enjoy speedier processing times for naturalisation applications, i.e. whether there is a variation between EU or non-EU applications? So I think it's important here to separate between, you know, the various groups, for example, refugees who just have well, possibly not processing, but certainly in terms of the residence requirement. But is there any evidence of that, say, particularly in Ireland? And another question by Ken McHugh: in the case of stateless persons, can they still be protected by means of United Nations documents or provision?
I can come in here, Fran, if you like.
Yeah.
If others don't have a contribution, or they can come in after. Just with respect to Julie's question, I'm not sure that there's any published information or information provided by the department, for example, in Roisin's study regarding varying times for individuals. I suppose what we would identify through the Immigrant Council of Ireland services, which may be mirrored in other services also like NASCs, is that certain nationalities might have quicker processing times as compared to others. And but I certainly couldn't, that's merely anecdotal. And I suppose there could well be differences in terms of delays that may be experienced, particularly when conducting background checks, depending on the difficulties in getting information from other authorities outside of the country, if that is an issue. But you know, there would seem to be some difference, but not necessarily. I would not like to infer that it was a difference in treatment between different nationalities. Just maybe possibly practical challenges, but I think it's an area that could be explored. It would be certainly interesting if information like that could be provided. And then there was the other question from Ken McHugh regarding statelessness and UN documents. I suppose to clarify for Ken, the only stateless persons in Ireland who would hold UN documents would be those who had also been granted refugee status, and those numbers would be quite small. Statelessness presents in other contexts outside of international protection, and where that happens, those cases are very, very difficult, and at best an individual, if they are informally recognised as stateless, and I say informally because the practice of the department is not to issue formal declarations of statelessness, at best the person will then be issued a discretionary travel document, and when it comes to applying for citizenship, that discretionary travel document is not accepted as evidence of nationality. And if a person wishes to apply for I suppose not evidence of statelessness rather, and if they wish to apply for citizenship as a stateless person, and given that there's specific provision for that under the 1956 Act, the person will still nonetheless find that this would be a very contested issue, and that statelessness is not accepted in the absence of a formal declaration of statelessness, which a different unit of the department will still provide or refuse to provide. So this is an area that is quite catch-22 for applicants, and they take years to resolve, in my experience.
Yeah, thanks for that. Thanks for that, Catherine. I suppose I'm just thinking to remind people that most of the discussion and indeed much of the European, particularly I think the academic debates, has been on citizenship acquisition through naturalisation. But for EU nationals residing in Ireland, very many of whom were born in the UK, it's just to remember that they and Roisin brought this up, may have acquired Irish citizenship in fact, most likely by either birth or descent, either being born in Northern Ireland like myself, which is outside the Republic of Ireland, but there's an entitlement to citizenship, or born in the UK to Irish parents. So it's just to kind of keep that in mind when thinking about pathways to citizenship more broadly. But now I've just seen the time, and we've run in a little bit to our break. I think to try and keep us to a morning session, it would be good if we could break by, if we could be back by 11:45. So this is just gives you a quick chance to run and get a coffee or a tea or whatever. Speakers, once again, I'd like to thank you most sincerely for a very, very interesting session. The questions we didn't get to, we will endeavour to respond to. The speakers can all see them there in the Q&A, and I very much hope you'll be joining us for the next session at 11:45. Thanks again. So now, if we're okay to start again, could people please, we're okay to start, could people please take their seats if they were taking a break. So now I'd like to welcome and introduce our chair for the second session, Angus O'Connor. Angus is a qualified accountant and chartered banker with an MBS in social management and strategy in banking. Important for us is he's now principal officer within the Department of Justice, which we in Ireland call our Ministry for Justice. And Angus has responsibility for service delivery in citizenship by naturalisation, family reunification, the atypical working scheme, and a number of other programmes. He's going to be chairing the second session now on citizenship requirements and integration. Over to you, Angus.
Hi, Fran. Can you hear me okay?
Can't hear you just at the minute. You may need to unmute.
No, unmuted. Can you hear me now?
Oh, hello?
Hello, yeah, I can hear you.
Yeah, okay.
Can
Great,
you hear me?
yeah.
Yeah, perfect. Okay, sorry for this slight technical delay there. It had worked perfectly earlier. Basically, I'll transfer over to Isil Houlihan from the University of Dublin, and has an experience in an interest in republicanism and the part played by citizenship in that. I hope I've explained that okay. Sorry, excuse me, Isla, over to you.
Good morning. Hello.
I can hear you.
Yes, am I coming across now properly?
It's good to know that I'm not the only one experiencing technical difficulties. Okay. You're fine.
Yeah. Okay. I'm going to share some slides. Is that right?
Okay. Yeah, we can see them.
Okay. So I want to thank EMN and the ESRI for inviting me to talk today. I've been asked to step back a bit from the details, the fascinating details that have been discussed earlier in earlier sessions, to look at the sort of underlying conceptions of citizenship and that might inform criteria for naturalization. That we can't take what citizenship is for granted, and that has implications for how we think about criteria for naturalization. So I'm not looking at the empirical details, which will be dealt with very well, but withdrawing more into a more theoretical and conceptual clarification mode in this presentation. So I'm going to talk about the different aspects of citizenship and how these blend differently in different conceptions of citizenship, why citizenship is important, why the citizenship of a specific country is important, the implications of the different conceptions for naturalization criteria, a little bit perhaps about citizenship tests, and then draw some conclusions. So citizenship is a very complex and contested concept, which has at least three aspects. It has the aspect of status, the legal and political rights that go with being a passport holder or a recognized citizen of a country. It has the aspect of activity or practice that goes with participation, engagement, and commitment to the common good among citizens. And it has the activity of membership, just the fact that you are a member of the group, that you belong in some way to the group. Now, these are connected in practice because if you think about it, they're all present in different ways in our ideas about citizenship, but they are separable. So you can have people who are not actually formal citizens who might participate a bit in the politics of the country, maybe at local election level or in different ways. You can have children who are members, but they don't have the rights, certain rights to participate in politics yet, or they're not active in politics. And you can have members who also don't bother participating in politics. So the three elements, the three aspects are detachable. And I'm going to argue that different conceptions of citizenship combine and prioritize these aspects of citizenship differently. So this is very broad brush distinctions I'm making. I'm going to distinguish three conceptions of citizenship based on, if you like, the prioritization of these aspects that are given. And but there are combinations and hybrids of these varieties as well that I don't have time to talk about today. So the first one, the idea of a legal status, is what might be called the liberal model, which is based on the freedom and equality of individuals who require protection from the state, by the state, against other people, and so forth. The second is the citizen as the active participant in society and politics, which I'll call the civic or the Republican model, because the civic can be a bit confusing in context of current discussions. And this might be seen as based more on the interdependence of those subject to political authority and how freedom and equality can be realized there, because there are connections here between the liberal and Republican model. And thirdly, there's the citizen as member of a political community, which you might call a communitarian, and in some forms, mostly nationalist model. And this can be based on a spectrum of groups and membership of groups, from a group of choice, like a club. What makes you a member is the fact that you choose, or the club chose you, to the idea of a common identity, which is more common in ideas of national membership, that you share a national identity. Now, these imply different contrast terms to the idea of citizen. I think this helps to see these more clearly. The idea of status, that of equal legal rights and duties, is contrasted to a subject, somebody who's under the command of a ruler, but because a citizen has an equal status and protection from domination or interference of certain kinds. The second conception, based on activity, is contrasted to a non-active person, somebody who's maybe a consumer or a client or a free rider, because citizenship is based on the idea of the practice and the engagement. And the third one, the membership or belonging, a citizen is again simply a member, which can be defined as an outsider, an alien, a non-national, because citizenship is based on the identity of membership. So again, to expand on the three conceptions, we can see that the status, or liberal version, emphasizes the rights and protections in laws and institutions. It identifies for the citizen limited obligations to obey the laws, to be tolerant of diversity, and makes political activity optional, because most of the weight is resting in laws and institutions. The civic and Republican adds the idea that laws and institutions don't solve all the problems of reconciling diverse people in society and achieving the common good of society, but you need committed citizens who trust their government, who are prepared to support their government and so forth, and who are prepared to participate in opposing the government, perhaps in some sort of context. So participation in self-government, public spirit, or commitment to the common good of the political community. And since these things don't always come naturally, it suggests that education of citizens is important, which liberals are not so sure about. The communitarian account emphasizes the shared identity with other citizens, which can range from a thinner sort of identity, like sharing certain principles or interests or whatever, to thicker ones, like sharing a common culture, a common nationality, a common ethnicity, or even a common race, depending on the basis in which the membership lies. Now, we've already heard today that the reason why citizenship is important, even today, where some people think it's been, if you like, partly supplanted by universal human rights, but particular citizenship continues to be important because it gives you the right, secure right to remain, to re-enter, access to other rights, to participate in national politics, protection abroad, and it symbolizes full membership. And you can see how the three aspects of citizenship are all in there in some form or other. Now, why on the accounts that I've outlined so far should someone have citizenship of a specific country as opposed to citizenship rather than being a subject to anybody? And the liberal conception actually doesn't immediately provide an answer because it's a universalist approach. It says everybody should be free and equal. And in order to define who should be a citizen of a particular country, it needs to bring in other principles. And I'll just leave it at that here. The Republican conception sees those who should be citizens as those who are interdependent in continuing subjection to a political authority, because they are potentially subject to domination and oppression, but it's only collectively that they can come to exercise self-government to perhaps be able to realize some of the common good through democratic politics and so forth. So it's the interdependence that counts there. And the communitarian conception rests citizenship on those who share a common identity, which again, in talking in terms of political terms, it's usually the idea of a nation of some kind, which is often a pre-political entity. So it's cultural or it's ethnic in some sort of way, perhaps, although there are different varieties of this. So there are overlaps between the liberal, the Republican, and the communitarian, but there are also these distinctions. So what follows for criteria for specific citizenship acquisition? We know that contemporary citizenship laws are both inclusive and exclusive. They regulate membership in particular states. We know that most people are citizens from birth through descent or through birth in the territory. They acquire their citizenship involuntarily, independent of their activity, their character, their diversity of beliefs and values, and whatever it may be. But most states offer naturalization possibilities under certain conditions. Now, some people would say that it's for each state to determine the composition of their own citizenry. But we could say also that even if states are free to determine their own membership, the criteria that they use to include and exclude people may be more or less justifiable or may fit more or less with one or other conception of citizenship. You could argue that citizenship is essential for those who are subject on a continuing basis to a particular political authority. And if naturalization conditions are very stringent, there's a risk of being over-exclusive or oppressive. This may emerge later. So we've looked already in other presentations at the kind of criteria for naturalization that are present in many countries. And we'll mention these as I look at the ways in which three different conceptions might look at these. So again, the communitarian view I'll start with, because if you like, it's the most, if you're more demanding, though there is a spectrum of communitarian views. But we would say communitarian view essentially sees, especially the communitarian nationalist view, which may be more or less ethnic, more or less cultural. The communitarian view would say, well, the members are those who share the identity, and if you don't share that identity, you don't belong. Or they could have stringent requirements, like requiring very long residence, as some countries do, requiring high levels of cultural integration in, let's say, the national language or the national culture, knowledge of practices and institutions, or even what might be called the national values, over and above broader liberal democratic values, in order to, if you like, confirm or guarantee that applicants for naturalization would come close to sharing the national identity. Again, the liberal perspective on this would be a spectrum. But in the first place, you might say that the liberal view inclines to include those who would otherwise be subject, because people need protection from the state in which they're subject. And they would generally see residence, and really quite short residence in some cases, as being the minimum requirement for naturalization. They might also say that it requires some kind of thin commitment to liberal democratic institutions and to evidence of toleration of others or whatever. And that's been one liberal view, that there are other liberal views as well. And in particular today, as I mentioned earlier, the liberal view in itself doesn't say who should be members. It says that everybody should be free and equal, but doesn't say who should be members of a particular state. And liberals are committed to the freedom and equality of individuals and the sustaining liberal democratic institutions. And it's been argued in recent times that liberalism alone is not enough, and just simple thin membership, thin citizenship is not enough to ensure that people will support liberal democratic institutions, or, if that's your concern, as it is of social democratic liberals, it won't generate the social cohesion that will support redistributive policies that states carry out. So two variants of liberalism. One is called liberal nationality, which supports some kind of integration into a public culture, thinner than the sort of communitarian account of if you must share a common identity, but an argument that there might be a public culture that surrounds the way politics is run, the way we operate politics in a liberal democracy that citizens need to share. And part of this will be learning language skills so that you can engage in liberal democratic politics. It will be less demanding than the communitarian. And this kind of argument is found in what's sometimes called the civic turn in recent years in some European countries, where there have been more demanding requirements in terms of language and civic knowledge for naturalization. I think in the context there, they're using the distinction between civic and ethnic. In the past, countries might have favored more ethnic criteria for admission, and that's regarded as excessively exclusive. This is now a more civic approach, but a less purely liberal approach, saying, well, all individuals who happen to live here can be citizens, but only those who share, if you like, the common public culture with other citizens, because of the needs of sustaining liberal democracy and social democratic institutions. And a Republican perspective inclines to include all those who are interdependent in subjection to a common political authority. So like liberalism, it takes residence to be the clearest shorthand, continuing residence to be the clearest shorthand for inclusion of people as citizens. Now, arguably, that even supports mandatory citizenship after a certain period. So rather than allowing people to become citizens, it might be said you could require people to become citizens, because otherwise they are like free riders on the democratic institutions and so on. They might be paying taxes and so forth, but politically speaking, they might be regarded as free riders on the institutions in the society. That's a very contested point, and I'm not going to argue for that here at this point. But in terms of criteria for naturalization, again, a Republican perspective might see languages as important for engagement and participation, and certain kinds of skills and civic knowledge as important. But it could be argued, I need to go back a moment. It can be argued that from a Republican perspective, because things are not defined in terms of what is required or prohibited, but in terms of also of the sorts of things that go beyond what can be provided by laws and institutions, but that need to be embraced by individuals. The development of individual dispositions and attitudes and commitments are really important, but they're things that can be encouraged, that can be educated, and possibly citizens by birth. Definitely citizens by birth, Republicans would argue, would need to be educated in this way as well, that it can be encouraged rather than required. It could be seen both as inappropriate, that you don't generate goodwill by forcing people to behave in certain ways. There are only certain things that can be achieved through requirements of law. We could distinguish between legal requirements and guidelines. We've become familiar with that recently. And that that it is not only more appropriate to do this, but that it also might be counterproductive to try to impose certain kinds of beliefs and practices on individuals. So we come to citizenship tests. And we know that there are tests of language, civic knowledge, skills, values, and attitudes. Now, for liberals, again, on the strand of liberal nationality that I have mentioned earlier, there's been an argument that it's reasonable to require certain levels of language acquisition, certain levels of civic knowledge, in order to ensure that people are capable of participating in the public culture, but that these would be less demanding than the sort of language test or civic or cultural knowledge test that would be required according to a communitarian or nationalist conception of citizenship, which could be much thicker and more substantial, because what you're trying to prove in the test that a person has adopted the identity of the country rather than simply has adopted the public culture, if you like, in the liberal perspective. So on one liberal view, the difference between acceptable kinds of citizenship tests and unacceptable kinds of citizenship tests would be the level of difficulty. It's reasonable to have a test if it's at a reasonably low level of difficulty. It doesn't require too much of citizens. But from a Republican perspective then, we might distinguish between, again, the characteristics, capacities, and attitudes that are desirable in citizens, which states may encourage, and the fixed requirements or particular levels of achievement that applicants must reach in order to qualify for membership. So Republicans might emphasize, if you like, the encouragement or the educative element of processes of naturalization. They also wouldn't assume necessarily that those who are applicants don't have these skills or knowledge already. Presumably, commitment to the common good is not something that's specific to a particular nation or political community, but things like language and civic knowledge might well be. So, in conclusion, a communitarian approach would emphasize identity, which is determined often in pre-political terms, can pose high integration requirements and stringent tests of language, culture, or values. A liberal approach emphasizes protection, legal rights, and thin duties with less demanding integration requirements. But if it can be argued that it requires some kind of cultural underpinning of a thinner or thicker kind, then there can be tests of language or civic knowledge. And among liberals, it's much more contested whether there should be tests of values and attitudes. I think for the most part, most liberals argue that you can't require people to hold certain values because liberalism is based on the idea of respect for diversity in beliefs and values. And a Republican approach, it's true, emphasizes more substantial participation and engagement among citizens. But integration could be seen less as a requirement, and this is going back to the catalyst crown distinction, if you like, less as a requirement, more something to be encouraged. And it could be argued that participation in language courses, in civic knowledge courses and so forth, or even some sort of experimental or practical political exercises would be more appropriate than tests. And even if we do think that citizens ideally would share an identity, it might be a thin political identity that they would need to share rather than anything more substantial, something that might be a byproduct rather than a prerequisite membership. Now, there's just one or two other things I'd like to say in relation to different conceptions and how they would affect naturalization procedures and requirements. Again, I think we might think of the communitarian approach as being more connected with discretionary processes, where it is for the community to decide. If a person doesn't wholly hold the same identity as the members of the society who have been born there, then the community can exercise discretion. But from a liberal and Republican perspective, discretion is less appropriate because of the way in which the people who are subject to government need to be able to have some protection or participation in that. So while a communitarian approach might say that citizenship is a privilege, a liberal approach might say that citizenship is a right, and a Republican approach might say that citizenship is a need. I think I'll just stop there. Thank you.
Thank you very much, Ilse. That was fascinating. So thank you very much for those very insightful insights. It leads in very well into our next speaker, Mikhail Polonetsky, who will talk about international practices in civics and language requirements linked to naturalization. Mikhail works with the Irish National Contact Point for the European Migration Network, the EMN, and is based in the ESRI. Mikhail holds a PhD from the University of Maastricht. I'll hand over now.
Thank you very much. Iselt, I think you should stop. Yes, exactly. Thank you. Okay, can you see the slides?
Yes.
So thank you very much. Today I will present some key findings from the report entitled Supporting Integration, International Practices on Civics and the Language Requirements linked to Naturalization. And this report has been co-authored with Sarah Groark, Emma Quinn, and Fran McGinnity. And it was published in late September this year. So what's the presentation structure? I will start with the background of this research and our approach to data collection. Next, I will present an overview of the language requirements which are related to naturalization in member states of the EU and the United Kingdom. Then I will present civic requirements which are related to naturalization in Europe. And then I will discuss some important learnings from our in-depth case studies. So what was the background for this report? The rationale for this research was that the migrant integration strategy in its Action 12 states that the introduction of both language and civic requirements will be examined. And this study contributes to a better understanding of such requirements in the international comparative, which is important context. And before we started collecting data, we conducted an extensive literature review on several interlinked topics, that is naturalization, citizenship, and migration policies and requirements. And this review served as a guide for choosing key dimensions of requirements for data collection. So in the next step, we collected data on various aspects of requirements. So their content, form, level of difficulty, associated fees, and available aids for 27 EU member states and United Kingdom. Then we explored whether and how language and civic requirements are present in 4 European states. It is Belgium, Finland, Portugal, and the United Kingdom at that time. So these case studies were complemented by 3 case studies covering also non-EU, but English-speaking countries, United States, Canada, and Australia. And I should mention that apart from the analysis of the existing secondary data, we conducted interviews with policy experts within European Migration Network, but also researchers and academics. And additionally, a very important source of information has been the research which was conducted within the frames of a study launched yesterday and presented today in the morning, that is this Pathway to Citizenship study. When we are talking about the limitation of the study, I guess there are 2 major ones. So first, it looks only at member states of the EU, so this is the European perspective. And second, it analyzes a limited number of in-depth cases or case studies. So let's move to language requirements. And what we could see in the mapping exercise is that in 24 member states, and the United Kingdom, there is a requirement of showing knowledge of language if a person wants to naturalize. And only 3 states, that is Ireland, Cyprus, and Sweden, don't have such requirements. When it comes to the ways of assessing language knowledge, our research found a variety of ways, but also a quite widespread presence of multiple ways to proving the knowledge. So there are different ways of testing, but at the same knowledge, but at the same time, you can take different routes in the same country. So in 20 European member states and the UK, the requirement of passing a test exists. So you need to take a test. There is also a variety of tests and the ways that that these tests are being administered. So they can be administered by universities, private companies. They can be external and independent tests, or tests which are tailor-made for the purpose of naturalization. In 19 countries, education certificates can count towards the requirement. So this means that participation in an educational system which is delivered and when education is delivered in the language of country of application can count towards this requirement. So we find a big variety here. It can be primary school, secondary education, or graduating from university course. So it can be a single course or a degree. There is a small number of countries which rely on interviews when a language competence is assessed during a conversation with an official. So this is a more discretionary type of assessment. And finally, in some countries, like in Belgium, participation in an integration course might count towards meeting this criterion. So basically, you participate in a course, and this graduating from this course gives you passes this requirement. What are the issues regarding to the levels of requirements? So one of the most important characteristics of language requirements is the level, so difficulty of language knowledge. And for the purpose of comparisons, the Common European Framework of Reference for Languages is very useful. It was developed by the Council of Europe to provide a transparent basis for assessment of foreign languages proficiency among other objectives, but this can serve as a benchmark for assessing the difficulty of tests. So it goes from C2, which is fluency, to A1, which is a very basic competence, language competence. So in 7 member states, the requirement is that the basic knowledge of language, which can be expressed by, as A2 level of this framework. And this means that users should be able to understand and use familiar expressions. 10 member states require B1 level, which is independent lower. And then in two member states, B2 is required, which is independent higher. In 4 member states, the required level is not specified. And in Bulgaria, there is a just generic statement regarding the requirement that it should be basic or elementary. And the recent report prepared for the Council of Europe indicates that over time, the language requirements have been more demanding. So there is more and more countries move up in the scale of Council of Europe. So when it comes to other aspects of language requirements, such as costs, exemptions and supports and evaluations have been included in this mapping exercise. And as for the costs, 12 member states apply some fee when a language requirement is required. In 11 member states, if a person follows an integration course offered by public authorities, he or she can be entitled to a language training support. And importantly, conditions such as age or illness or disability are basis for exempting from language requirement. It's just in some member states. And the exemption on the basis of age is present in 10 member states, while disability or illness is, can be seen as a reason for exemption in 13 member states. Only in few member states, status of vulnerability, such as refugee status or low educational attainment, is seen as a reason for exception from the language requirement. And interestingly enough, Finland stands out as the only country we analyzed in our study where it is possible to satisfy the language requirement in sign language. What we found across the board was that there is no evaluation of language requirements. so no evaluation has been done. In some member states, language tests are being outdated, but this is the most advanced form. And also it is important to note that the Council of Europe warns that its language framework should not be seen as a proxy of integration, as it was devised for other purposes, exactly for this purpose of comparative analysis of difficulty of language requirements. Let's move to the second category of our requirements, which are civics requirements. And what we see in our mapping exercise is that in 18 EU member states and the UK, there is a requirement of knowledge of civics as a part of naturalization procedure. And during the last 20 years, what we see is that the requirements have been on the rise. In 9 member states, there is no requirement of any knowledge of civics. And these countries are Cyprus, Finland, Ireland, Italy, Malta, Poland, Portugal, Slovenia, and Sweden. As in the case of language requirements, there is a variety of ways in which applicants can prove their knowledge of civics. In 11 member states and the UK, individuals need to pass an exam. Such exams are mostly multiple choice tests. Are they computer-based or paper-based? And in 5 member states, the civic requirements are met by passing an interview. And whereas in 2 member states, participation in orientation or integration course would be sufficient. What is included in the civic requirements we study, and this was raised in the previous presentation. So most popular themes cover the knowledge of constitution, political and democratic system, history, geography, culture or customs. Less common, are more practical aspects of life in a given country, such as access to public services or citizens' rights. It is very difficult to find on how content of these tests or requirements is devised, and literature points to the lack of transparency and the risk of study and the risk that handbooks which are used for and the risk that the study handbooks which are used by examinees can portray very subjective opinion on those responsible for their development. An interesting aspect of civic requirements is that they are conducted in national languages, and this means that such requirements, such as a way of implicit language testing, actually, where the level is not specified and the language might refer to abstract concepts, like we mentioned, democracy, customs, this kind of things. In most of the EU states, an applicant needs to pay a fee for sitting an exam, and in 8 countries, a separate costs apply to taking of the test, while in others the costs form part of the overall citizenship application fee. So it can be separate fee or part of a joint fee for a naturalization procedure. And in 2 countries, the requirements are free. So this is Belgium and Luxembourg. And in countries such as Hungary, Latvia, and the United Kingdom, applicants are charged for exam materials. And when we look at the exemptions and evaluations of this type of naturalization requirements, we see that several countries apply exemptions which are related to disability or illness or age. Few countries provide for systematic exemptions for persons with low literacy. And in Spain, for example, persons who are illiterate may apply for a waiver or an adapted exam, so that is adjusted to the competences of this person. And adoptions which are available for people with disabilities are present in most of the member states. Again, when it comes to evaluation, there is very little known about on the extent to which countries that have a knowledge of society civic integration requirement base their testing on research on evidence. So it's very hard to find how these tests are being prepared. So, for example, Street and colleagues found that the While in the Life in the UK test, I will talk about this later, was relatively straightforward for those who could speak English. It was more difficult for those with a lower level of English, and particularly people who had little formal education and those who lacked formal literacy. Another study found that those who had experience of the life in the UK, learning materials found the knowledge gained useful and interesting, but not critical. So basically, it was an interesting topic, but not essential for the presence in the UK. So let's move to the case studies, and let's start with Portugal. Portugal is a state in which migration and citizenship acquisition on a larger scale is relatively recent phenomenon. So Portugal requires only the knowledge of language at A2 level. So if you recall the Council of Europe framework, so it's relatively basic. No civics requirements exist in this country. Language requirement has been in place since 1950s, but it was done in an informal way. So since then, the procedures became more formalized, and testing option, which is the main way of proving language knowledge, was introduced in 2006. The knowledge of Portuguese can be proven in many ways. It can be tests, which are based on a common framework and overlooked by academic institutions. It can be also educational diplomas or accredited language courses. When it comes to exemptions, they are possible for citizens of countries where Portuguese is an official language, those with serious health problems, disability, those who are aged over 60, and those who are illiterate. And I should state here that a considerable share of applicants originate from Portuguese-speaking countries. So this means that they are waived from the language requirement. Public authorities offer free language PPT program, which is called Portuguese for All, and this program targets applicants for permanent residence or naturalization. And graduation from this program satisfies the requirement, and approximately half of participants graduate from it successfully. Let's move to another case study, which is Belgium. Belgium is, I have to admit, a relatively difficult state to study because of its federal structure and presence of 3 official languages. So it's French, Flemish, and German. The civic requirement, which is called social integration, was introduced in 2012 and can be met in a number of ways. Receiving diplomas or graduation from at least upper secondary education, completion of a course, or participation in a special integration program at no cost, and it's quite important. A notable way of meeting the civic requirement is a continuous economic activity for at least 5 years in Belgium. Because of its federal structure, integration program, Belgian federal structure, integration programs differ among communities. So the differences concern scope of these programs, but also the level and amount of knowledge participant is expected to demonstrate. And when it comes to the language requirement, it has been set at A2 level for all 3 languages, and completing participation in social integration requirement is sufficient. That's also important. But there are other ways, such as upper secondary education diploma or certificate, and so on. Challenges that have been identified show that in terms of social integration and language requirements, no one-size-fits-all solution exists. Migrants can have different needs and have different backgrounds, such as low level of literacy, low level of educational attainment, and so on. And further, the provision of courses needs to be accompanied by additional services, such as childcare for those who participate in these courses, or transport in rural areas as well. And it should be stated that no formal evaluation of these requirements exists in Belgium. Some evaluations cover only particular integration programs. And the impact of the programs is positive in terms of ability to acquire information, but this effect declines with time. The providers of integration programs noted a need for tailored provisions, such as provision of civic component in the language of origin, for example. So if you recall this issue of civic requirement, which is expected to be passed in the language of a country of arrival. So let's move to another slide, another case study, which is the United Kingdom. Here, since 2005, specified language and civics requirements have been part of the naturalization procedure. And in principle, the language requirements can be met by knowledge of English, but also Welsh and Scottish Gaelic. So initially, a double path had been available, which meant that an applicant could opt for language certificate and the knowledge of language and life in the UK test. Or take part in the language course, which involved the civic component. But since 2015, two tests need to be passed. So Life in the UK tests, which has been based on the handbook, and when it comes to the language, only B1 level CELT test, which stands for Secure English Location Test, is allowed. So only tests from selected companies are accepted, and these companies are participants in tenders. So in general, research indicates the positive assessment of the integrated course, such as an integration exercise itself. The challenges include the reliance on for-profit courses or the need to coordinate preparations for tests with childcare. Also, the effectiveness and availability of testing in Welsh or Scottish Gaelic seems a problem, and in fact, it's relatively hard to find statistics on this issue. So what are the main policy implications stemming from our research? So to start with, there is no one-size-fits-all solution to naturalization requirements. They differ in scope, as we showed, difficulty, and ways of proving knowledge. Also, states have different migration outcomes, integration policy priorities, but also different historical legacies which are related to migration. What is important is that the costs of running systems of requirements are unknown. Often these systems are dispersed between different administration branches and are co-financed by fees. The recurring theme is the need to provide a system of public support for individuals with lower educational attainment, language competence, or individuals with disabilities. Due to multilingual framework in Ireland, a consideration has to be given how to prepare and test candidates in English, Irish, and Irish Sign Languages. So there is more than just one language here. But also from the perspective of integration, the solution which provides more support is a course rather than a test of knowledge, and this has been indicated by some research. And finally, it should be stressed that it is essential to perform an ex-ante analysis as well as an ongoing evaluation of such policy instruments. They need to take into account diverse voices of stakeholders, so not only those who participate, those who are subject to this test, but also migrant community and wider community. Okay, thank you very much. I will stop here.
Thank you very much, Michael. That was very interesting. A lot of food for thought. Can I just have a reminder to everyone that there is a Q&A function available to people. So if they would like to participate, would be gratefully received. So if you could just use the Q&A function to raise any questions that you might have. Our final speaker is Ricky Van Oers. Ricky is a lawyer, has a PhD on the topic deserving citizenship tests in Germany, the Netherlands, and the UK, 2014. So very interesting topic, one that's quite close to my own heart at the moment. She is currently the research fellow at the Centre for State and Law at Rambun University and the business developer of the University Centre for Professional Legal Education. I hope I've done you justice, Ricky.
Yeah, you have. Thank you very much. Thanks for the invitation. And I hope everybody can bear with me for this last presentation. I'll start sharing my screen. And if I do this, perfect. So this is the title of my presentation. I'm going to zoom in on the language and integration requirements for naturalization in the Netherlands and Germany. And I would like to make two short remarks before I start. The first is, I think, I would like to stress that obtaining the nationality of the state they are living in is not only important for the individual migrants, it's also important for the state itself, for liberal democracies that most European states claim to be. If a large part of the resident population is not a citizen, then that part of the population cannot influence the process of political decision making. So there will be a problem of democratic legitimacy. So I think it's important to stress that as well. And the second point I would like to make is that well, it has become apparent that Ireland is also considering to introduce language and integration requirements for citizenship, possibly even a citizenship test. It is one of few countries that don't have this requirement now for naturalization. I would like to say to all the Irish participants, well, think before you leap. I hope if at the end of this presentation, the warning will become more clear. So the Netherlands and Germany have formalized their language and integration requirements for naturalization between 2003 and 2008. In the Netherlands, a naturalization test applies since 2003, in which both language and knowledge of society is tested. And Germany has formalized its language requirements since 2007, and an Einbürgerungstest applies since 2008. It's a test, a multiple choice test consisting of 30 questions on German society, and all the questions and answers are published, so you can use that to prepare for the test. So prior to the introduction of these formalized citizenship tests in both countries, language and integration were already required for everybody who was interested in naturalization, but it was tested very informally in an interview with a local official. So the introduction of formalized citizenship test has made access to nationality a bit harder. So the questions I would like to address in this presentation are the questions of why the citizenship tests have been introduced in both countries and which effects they produce. I've recently published an article about this in Ethnicities, and then I used these two questions to address a more theoretical question, which was also touched upon by Isolt earlier, whether the test can be justified in the liberal model of citizenship. But it will take too long for me to elaborate on that, so I'll just focus on these two questions for now. So the level of knowledge required, very briefly, in Germany it's level B1. As regards language, all 4 skills are tested. Knowledge of society, as I just explained, the Einbürgerungstest. The costs for this Einbürgerungstest are 25 euros per try, and the costs of the language test vary. And then there are also, of course, the costs for application of for naturalization, which are 225 euros for an individual application. And then the Netherlands, the level of language required is a bit lower. It's level A2, also on all 4 skills. But there are plans, as Maarten has explained in his presentation, to raise this level to B1. In the Netherlands, knowledge of society is also required. And the test which is currently applied, it's the same test as the test which applies in the framework of the Integration Act, which introduces an integration obligation to newcomers. And the final test in the framework of this act is the integration examination. It consists of a total of 6 different parts. The test is partially computerized, and the total costs are 290 euros. But then there are also the costs for preparation for this test, and numbers that have been published by the ministry show that these costs are on average 5,000 euros per person. Of course, in Germany, there are also costs made if you want to prepare for the language and the knowledge of society requirements, but there the government, in the framework of the Immigration Act, pays for a substantial part of those costs. In the Netherlands, the costs for a naturalization application are also higher than in Germany. I looked it up. It's now €901 for an individual application, or 1,150 euros if you apply together with your partner. So now to address the first question, the reasons for introducing citizenship tests, I'll focus to start with on the Netherlands. The Netherlands in the 1980s applied the minorities policy. And the basic assumption there was that a strong legal position will benefit the integration of immigrants in society. And as we've learned from Maarten's presentation, this assumption is actually proven to be true, at least in terms of labor market outcomes. Back then, those research results obviously were not known yet. And other research has shown that it has also a positive effect on the integration in terms of political commitment, belonging to society, and other aspects. So the Dutch Nationality Act, which was introduced in 1985, was used as a means to achieve the ends of the minorities policy. So citizenship was really used as a catalyst. The goal of the Dutch Nationality Act was to increase the number of naturalizations. So citizenship as a catalyst for integration. In 1993, there was a proposal to amend the law, the citizenship law again, to even further open up access to citizenship. It was proposed that the requirement to renounce one's original nationality upon naturalization was deleted. And at the same time, the proposal of law contained a proposal to reformulate the language and integration requirements in order to promote uniformity in its application, because this requirement was criticized for its vagueness, which led to a divergent application of the requirements in the practice, which was considered to be unfair. So in the debates concerning the proposal to amend the law, the Christian Democratic members of parliament, as well as the conservative liberals, started to express a different view on integration and on citizenship's role in integration than the one that was the assumption in the minorities policy. They saw naturalization as the crowning of the integration process, as the legal and emotional completion, and they claimed that citizenship should be something to actually be proud of, something that should be earned and not given away too easily. So they started to lobby for higher naturalization requirements, and then notably more stringent language and integration requirement for naturalization. They also claimed that this was necessary in order for future citizens to be able to fully make use of the rights and duties that come along with citizenship. What use is Dutch citizenship? Some Christian Democratic parliamentarians would say, if those attaining it are not even able to make use of all the rights and duties that come along with it. The government was challenged by the opposition parties to address immigrant integration with guts. The immigration policy was blamed for it to be not demanding enough to pamper immigrants. So eventually the minorities policy was replaced by the more demanding integration policy, which, in the framework of which in 1998, the Newcomers Integration Act was introduced. And this act required newcomers who settled in the Netherlands for a non-temporary purpose, mainly family migrants, to participate in an integration program, which was terminated by a sort of an exam, but you could not really pass or fail this exam. It was merely meant to measure which level of language skills somebody would have attained after following this integration program. And the level that was strived for was level A2 of the Common European Framework for Reference of Languages. And even though this test was only used as a means to measure the level achieved, some members of parliament, notably the Christian Democratic members of parliament, refer to this as the world turned upside down. Why, they said, is more required from newcomers who have just arrived in the Netherlands than of prospective citizens who can simply prove their integration in a simple conversation with a municipal official. So this eventually led to an amendment of the Dutch Nationality Act in 2003, which introduced the naturalization test. And prior to the introduction of this test, the government promised that the formalization of the language and integration requirement would not produce selective effects. But at the same time, the replacement of the informal interview with a civil servant with a formalized test meant both an increase in the level of skills required and higher cost to fulfill the language and integration requirement for naturalization. So non-surprisingly, as we will see later, the numbers of naturalization have decreased after the introduction of a formalized test. So in 2007, approximately 4 years after the introduction of the naturalization test, this test was replaced by the test in the framework of the Integration Act. And the goal of this act, which replaced the Newcomers Integration Act of 1998, was to ensure that immigrants could participate actively in society and the economy. Compared to the naturalization test, the integration examination is longer and harder and more expensive. And as we have already seen, there are plans now to raise the level of language skills required for naturalization to level B1, as the government has claimed in the most recent coalition agreement. Dutch nationality is something to be proud of and which should be earned. So with this, I would like to, I'm saying all this to show that once the choice is made to introduce a formalized test to see whether an immigrant has integrated enough to become a citizen, the requirements are only made more stringent. It always goes in the direction of more strict conditions. So once the first step is taken for the formalization, it's easy to raise the bar even more. I saw that in the document that was sent along with the invitation, in the plans, the Irish plans to address migrant integration, that reference was made to the common basic of the common principles for integration of the European Commission, that integration is a two-way process, that not only the burden should be placed on the immigrants wanting to become citizens, but there's also a responsibility of the receiving society to promote integration and to erase forms of discrimination. But in the debates that have taken place in the Netherlands prior to the introduction of citizenship test, integration as a two-way process did not play a role. The burden is very much placed on the side of the immigrants. So then, quickly moving forward to Germany, there was a strict citizenship regime until the beginning of the 1990s, when a simplified naturalization procedure was introduced. Until then, naturalization was very much at the state's discretion, and it was very hard for immigrants to attain German nationality. But this changed in the beginning of the 1990s. A further liberalization occurred in 2000, when a new Citizenship Act entered into force. And the goal of this act was to increase the number of naturalizations in order to improve immigrant integration. So again, here, back then, citizenship was seen as a catalyst to immigrant integration. At the same time, in 2000, a language requirement was introduced, which did not apply in the simplified naturalization procedure introduced in the 1990s. The justification for this integration requirement was that future German citizens should be able to understand German media and to communicate with German people, and they should be able to participate in the process of political opinion making. but still naturalization seen as a means for integration. After the introduction of the changes in 2000, some conservative German states called for more uniform requirements because they feared the phenomenon of naturalization tourism. And this is the phenomenon that immigrants interested in German nationality, living in a German state that applied very stringent conditions for naturalization, or that would interpret these conditions in a very conservative manner, would temporarily move to a state which would apply these conditions more leniently, acquire German nationality, and then return back. So they lobbied for a formalization of the language requirement for naturalization, and in 2007 the law was amended, and in the law the requirement of oral and written language skills of level B1 was introduced. So it was made more uniform in the whole of Germany. So every German state needed to require oral and written language skills at level B1. We've also seen in the Netherlands as a more uniform, the call for more uniformity in the application had led to a formalization of the requirements, which entailed more strict requirement. So formalization automatically, I would say, means more strictness. And at the same time, in 2007, the requirement of having knowledge of the juridical and social order and of the living conditions in Germany was added. And as a justification, the government said that they intended to observe a gradual rise in integration policy, with naturalization being the end point. So instead of a means for integration, naturalization here was also more seen as the crowning or the end point, or Schlussstein, as they say in Germany. When introducing the more stringent requirements, reference was made to the Immigration Act of 2005, which required language skills at level B1 and basic knowledge of the juridical and social order and of the living conditions in Germany for permanent residents. So here the requirements for permanent residents, as in the Netherlands, exerted an upward pressure on the requirements for naturalization in order to observe this gradual rise. So as in the Netherlands, the idea was that at least the same level of skills needed to be required for naturalization as for permanent resident status. Well, as I said, the formalized language requirement applies since 2007 and the Einbürgerungstest since 2008. And here as well, integration as a two-way process. There was not really, this was not really an issue during the debates. Here as well as in the Netherlands, the burden for integration is placed very much upon the immigrants and the prospective citizens. So now turning to the question of what affects the citizenship test used by Germany and the Netherlands produce, I'll address now. I answered this question by analyzing relevant statistical data and via interviews. So I've spoken with in both the Netherlands and Germany with immigrants interested in naturalization, with representatives from immigrant organizations, with municipal officials, with language teachers. Just to see what the effects of formalized language and integration requirements are. And the two main conclusions regarding the effects are that the tests lead to lower numbers of naturalizations and that the test affects certain categories of immigrants more than others. So in this figure, you can see that after the introduction of formalized language and integration requirements, the numbers of naturalizations decrease. These are absolute numbers of naturalizations in both the Netherlands and Germany. In the Netherlands, the number of naturalizations has halved after the introduction of the test, and this decrease has a permanent character. So the requirement was formalized in 2003, and in 2018, 15 years later, the numbers are still half as low as prior to the formalization. Then you could also, of course, ask to what extent is a test to blame, because the numbers of naturalizations obviously also depend on on numbers of immigration and other conditions for naturalization. So I also looked at the pass rates in the test. And well, you can see from these numbers that for a substantial part of everybody who takes the test, the level is too high. In the years 2011 to 2014, there's a pass rate of 67.5%, meaning that for at least a third of all applicants for naturalization, or at least a third of all those who participated in the test, the level was too high to pass. Whereas when integration was tested via a local official, this was hardly ever a reason to refuse a naturalization application. And the pass rates only says something about those actually taking the test. They don't give any insight into the dark numbers. So people who think, oh, this test will be too hard for me anyway, I won't even bother to prepare and to take the test. This will be a waste of money. Naturalization is no longer something which is for me.
Ricky,
yes.
just aware of the time, just a time check there. So,
okay, sorry.
no
how many more minutes?
You're technically up, but
okay, well,
if you can wrap it up maybe in a minute or two, that'd be
sure.
perfect.
Well, in Germany, I guess the slides will be distributed, so you could you can read these slides. I would just like to focus on a few quotes from immigrants I interviewed in Germany and the Netherlands, just to show that there are actually two categories of immigrants for who the introduction of tests does not contribute to their integration. And then the first category are immigrants in disadvantaged positions who experience trouble finding their way in society, the elderly, people with little or no formal education, traumatized refugees, women in disadvantaged positions. A few quotes. 74-year-old Iraqi couple, 8 years in the Netherlands. We had a really good laugh when we heard that we needed to take the test. We only came to the Netherlands when we were aged 66. My wife speaks a little bit of Dutch, but I don't speak Dutch at all. I speak good English, and that is why I've always managed well. If we are not exempt from the test via the doctor, we will need to forget about Dutch nationality. We will not take the test. That's a waste of time. 33-year-old Iranian national in Germany. I only went to school for 4 years in Iran. I now have a family and I have to make sure that there's enough money. I cannot learn from what is required. And I know that many with me have no possibilities to learn everything. From what I've heard, the language test is really hard. My language and script are totally different. I've learned it a little bit. It is enough to cope with work, but it's too much for me to learn everything. So these categories of immigrants are effectively barred from naturalization. And then there's the category of immigrants who are obviously integrated and they feel belittled and frustrated that they have to take a test, which in their opinion is an insult. And tests send the message that they don't belong. And for them, obviously the test is not a contribution to their integration either. And I've mentioned these two small quotes here, and I suggest that everybody who's interested can read this later on, and I'll end my presentation here.
Perfect. Thanks very much, Ricky. I appreciate that, and very insightful, and I'm looking forward to reading them myself. We've run slightly over time, but we're coming into the second section a bit behind time. So just in relation to questions and answers, I think there's 4 possible questions. Let's go through it. First question up, is it timely for Ireland to introduce a basic language and civic requirements when applying for naturalisation? As a department official, I won't be commenting, so I'll leave that to, I don't know if anyone wants to take that.
Sorry, could you repeat?
Is it timely for Ireland to introduce a basic language and civic requirement when applying for naturalisation? So, I suppose, from a departmental point of view, no decision has been made in relation to language tests or civics tests. That's ongoing, so I suppose we're in an information gathering mode, so that might be the most appropriate answer at the moment from a departmental point of view. But Ricky, you may have some insights there that you'd like to share.
Well, I think also from Michael's presentation, it became clear that, and I hope from my presentation as well, that tests are not necessarily the right means to promote integration. So if the promotion of integration is really the goal you want to achieve, then testing, especially if you make one test for everybody, so there's no difference in levels to attain, so everybody has to jump through the same hoop. It's not necessarily the best means to achieve the end of integration, and maybe the introduction of language and integration courses, which are offered by the government at free of charge, is a better way to go. And as I've shown, as the cases of the Netherlands and Germany show, once a formalized test is introduced, the level which is required only increases over time. It's like this mechanism which has entered into force in the Netherlands and Germany, that once you start testing, there's no stopping. It's like the process of path dependency. New requirements are introduced for immigrants, then automatically the requirements for citizenship go up. No questions asked. We've seen that in the Netherlands and in Germany, there is a negative effect on the numbers of naturalizations. A certain part of the immigrant population is effectively barred from acquiring citizenship. I mean, there's ample research that proves that this effect is taking place, but there are no questions asked in the parliament whether this is a desirable effect or not. There's ample research that shows the benefits for integration when somebody has become a citizen. Now the reality is that a large part of the immigrant population cannot attain citizenship, with all negative consequences which ensue, but there is no debate on whether we want this and whether some of the restrictive changes that have taken place should be reversed. So I mean, those are important issues to concern prior to introducing a language and integration requirement, I think.
Perfect. Thanks, Ricky. Michael, I'm not sure. The questioner thought that this question might sit with you, so I'll call it out. It relates, was there any review conducted of fees of naturalisation to ensure that the cost was reasonable and not used as a deterrent? Action 10 of the immigration strategy. I don't know if you're conversant with that.
Yes, so such reviews are, as far as I know, that they are done on regular basis. And when it comes to groups which are referred to in this consultation, it's those who naturalized recently and those who are considering this procedure. This is what I can say. Thank you.
Perfect. Oh, no, that's good with me. And then Isel, the question is for you. Do you consider the level of application fees as a criteria for citizenship, as it might be viewed as linked to certain levels of income expected of the applicants? Is it common across many countries that immigrants tend to be employed in low paid jobs and can struggle financially? This is a consequence where fees costs are high, create real barriers and make an application for citizenship. So I presume the questionnaire is basically asking what's the implications from an immigrant point of view, being maybe at the lower end of the socioeconomic scale in relation to the fees set. I don't know if you have a view on that.
Yes, just thinking back again about the conceptions of citizenship that I was talking about earlier, it would seem to me that, you know, the central emphasis in those was whether you have identity, whether you are going to be in need of protection, or whether you should be a participant in political life. And the rate of the fee entry really shouldn't be a bar. It's not the main concern. So there may be fees for application for citizenship, and depending on a lot of other factors, it could be argued that people should pay the cost, administrative cost of that partly. Though it might also be argued, as Ricky has mentioned, that it's in the interests of the state also that long-term immigrants become citizens because of the ways in which they contribute to the state, as well as the interest of the immigrants. So fees should not be so high that they create a barrier for people. And then it could be argued, if you adopt a more facilitatory approach to access to citizenship, it could be argued they could be kept low. So if the considerations for access to citizenship are matters of social participation, political participation, sharing identity, or being subject to the rule of a political authority, the level of income might not be the main thing that would be a consideration. You would not be trying to exclude people because their income was low. That wouldn't be a consideration. You certainly wouldn't be trying to exclude people on the basis of high fees. And it could be argued from any of those points of view that, at least from the Liberal and Republican point of view, that fees should be lower rather than higher.
Perfect. Thanks very much for that. There's one question that just came in there. I think I welcome all three panelists' views on it. It's one that I'm struggling with myself. Got to do with those who are illiterate, deaf, blind, or otherwise maybe educationally challenged, if I use that term, and the use of civic and language tests. And I note, Michael, that you specifically mentioned the Finns have sign language as one of their three languages.
Yes, so it seems it's essential if you want to achieve this goal of integration, but also to assess the skills in a fair manner. I think it's essential to take into considerations all these conditions. So what you see in several European countries is that the tests or the requirements are adjusted to the needs of these categories of individuals. But on the other hand, you could see that in some other states, in evaluations, there is a challenge of meeting these needs. So I think this is exactly this quest for a constant evaluation of this type of initiatives to guarantee that every person, irrespective of his or her needs, can participate in this type of requirements. Thank you.
Thank you. I think I see the numbers dropping off down to 61, so I think everyone's breaking for lunch. With that, I'll just hand over to Fran.
Yes, thank you, Angus. Thank you very much for that. And I've certainly learned a lot this morning. It's challenging to pack a diverse range of views and interesting discussion into a Zoom session like this. I suppose as a co-author with Michael of the Supporting Integration report from September on requirements, I just reiterate what Ricky was saying. I think one of our conclusions was that courses may be more supportive as tests may be difficult to design, difficult to administer, they may be costly and exclude people for some unintended reasons. Before we finish today, I'd like to hand over to Emma Quinn, head of EMN Ireland, who just wants to say a few words before we go.
Sorry, that's just a few technical issues here. I won't keep you long. I just wanted to say thank you. A big thank you to our expert speakers. I think we've had a really, really interesting morning, and I really appreciate them taking the time to share their expertise with us. A special thank you also to the chairs, in particular, I think probably to Fran, who stepped in at a very late notice and did a great job. So really appreciated Fran. To Evie McCullough, who's been behind the scenes, making it all run smoothly. So thank you, Evie. And finally, of course, to the participants, thank you all. I hope you had an interesting morning. I feel like we all learned a lot on a topic that's close to a lot of people's hearts. If you have feedback, please do send it to the EMN Ireland email address, which is emn.ireland at esri.ie, and we'd love to learn from your experience. So thanks again.